I don't think it has any specific focus for Māori.
Sorry, what was the name of that?
I think they call them NEETs, not in education, employment or training, and policies to address that. So obviously it is of a concern to the Crown, but I don't believe that they're going about addressing it in the right way or in a tiriti consistent way, given that Māori make up a substantial proportion of that negative statistic, and given that they are partners under tiriti, they should be heavily involved in designing solutions to that situation. Mr. Houghton's probably got some excellent ideas about how to address that, but I'd probably just leave it at that.
Could I put that question in writing?
Yes, sure. Yeah.
Thank you very much. And I notice also that one of the recommendations is that the Crown consult with Te Raki Māori on ways to revive the Northland economy, and Mr. Houghton's suggestion this include a 20-year tax benefit or break for businesses wanting to come specifically to the Te Pātu Rohe to establish their businesses and kickstart economic growth. So it would seem that he might be supportive of Mr. Sharrock's idea yesterday of a Te Tai Tokerau development.
Yes, yeah, I think so. Yes, yeah.
Ma'am, if I may just interject here briefly, and thank you for the offer to put the question in writing as well. A lot of the material that Mr. Houghton has referred to in his brief comes back to the problems that are apparent in the youth, and of course Kaitaia suddenly appearing in the last few years as apparently, you know, New Zealand's suicide capital, and most of them are in fact young people, and getting right down to, I think there may have even been one pre-teen, which is just beyond tragic. Most of the comments that Mr. Houghton has made so far are at what you might think of as a micro level, and so there are dotted through his evidence references to all sorts of situations which require addressing, and in fact, of course, is exactly where He Korowai Trust is operating, and that's where he sees it, because he literally walks out his door and sees the kids on the street, and then goes into their homes and so on. And then, but then going on beyond that, someone like him who's now had 17 years in this work, plus the many years before at the Waiparaoa Trust, he has been involved in Crown operations, particularly I think by Ms. Turia in her housing policies, but I think also he would be very keen for himself and people like him to be involved more, as Ms. Patterson has said, in the consultation and the design of interlocking policies that work together for the benefit of the actual problems on the street, to benefit of the resolution of them. And that comes at whānau level, whānau support. Financial independence he sees as a way out of some of it, but as he mentioned, you know, they are people whose wairua is circling it with no place to land. And so I'm sure in answer to your question he will have more, but I think those are some of the key themes within his evidence.
Well, it would seem absolutely crucial that Māori, and particularly those who have such broad experience of these problems that young people are facing, should be involved in the design. And it seems amazing if in fact we've still got to the point where they may not be involved, even in 2017.
Tautoko. and that's part of the problem, I think, that we've seen if I may take it slightly further, with also a lot of the Crown responses back in the Crown hearing week, where it appeared as though it was still a lot of the decision making is still taking place in Lambton Quay, or possibly wherever the government buildings are here in Whangarei, but there is still far too little communication and involvement of the hapu and of the grassroots organisations such as Mr. Houghton's. And we're all well aware of the Wellington bubble, where the public servants talk amongst themselves and devise fabulous policies, and then they talk to the ministers and so on, but that's not necessarily meeting the need on the streets of Kaitaia or Kaikohe or Kawakawa.
Well, that is the most fundamental change that has to happen.
Thank you.
Thank you, Ms. Patterson.
Thank you.
Thank you for your presentation of those closing submissions.
Thank you.
And thank you, Dr. Gilling.
Just to note that Mr. Houghton was intending to be here, and Ms. Rongo and Ms. Hockley worked hard to make it possible, but in the end, due to communication breakdowns and so on, he's actually still on the road as far as we understand, so sadly. He was going to be here and could possibly have just popped up and sorted out your questions straight away. So our apologies for that and acknowledgements to him.
Thank you. Mr. Poe. And what document is Mr. Shepherd? I don't have any document filed by Mr. Shepherd.
I filed the document, sir.
When?
Last night.
Well, it's late then.
It is late, sir. It was a brief opening, a closing statement for Te Kutu. They are here, sir. It shouldn't take long to present.
These were due on the 19th of May. I have a memo from Mr. Shepherd saying that they were going to be filed on the 16th of June. Nothing was filed on the 16th of June, but we get something yesterday, last night.
That's correct, sir.
After hearings. What's the excuse and why should we accept them?
Well, sir, the real issue is that in terms of my mahi, and I would submit this, sir, that I am probably the only practitioner here that not only practices in Dargaville, but also Kaikohe and Kaitaia.
So,
sir, I have been very busy in terms of dealing with people in custody. The criminal jurisdiction is going through the roof.
Well, if you're not able to do it, then you should get someone. You should hand the brief on to someone else, shouldn't you?
No, sir. I take responsibility for this evidence. It's a journey that I've embarked on since 2008.
They're closing submissions. I made a direction in December 2015 in order that people could start on their direction, or start on their closings, so they could get paid legal aid. And here we are receiving them. Well, the closings for this hearing were actually first set for March of this year. Then they were extended out, and we've only just receiving them last night.
In that regard, sir, in terms of that December direction, I was audited from November to January. All my files were down with the Ministry of Justice. But in relation, sir, to where I work, Your Honour, I work with Douglas Blakey, lawyer of Kaikohe. I am essentially the sole practitioner in this field. I do not have any juniors. I do not have any legal secretaries.
Well, Mr. Poe, you've prepared these. How come you're not presenting them?
So I prepared the closing submissions. I received a request from the kaumātua of Te Hukutu, who are here. who you will have seen have been present throughout this whole journey that the tribunal has taken. The preparation of those closings, to achieve that I took a cursory view of the evidence, because you'll see them all set out there. I still think that, notwithstanding the fact that I developed those, that the more in-depth knowledge about the claim, given that it was Mr. Shepherd and Ms. Tufare that actually prepared their evidence, their understanding of those issues that I've glossed over throughout that closing submission would be of more benefit to the tribunal should they have questions that may have arisen. I do note that there was a statement of claim.
We probably won't have any questions because we've only just received it.
And that's fair, Sue. But I do note that there was a more comprehensive statement of claim that was filed on the record a couple of weeks ago, and I just thought I thought it might be better for the tribunal if the evidence in the pockets where that evidence might be found could be highlighted, and if perhaps some attention drawn to some particular points, so that when you do retire and go to consider the claims and consider the statement of claim that has been made for Y700 and exercise the Section 6 duty, that this would be of assistance to the tribunal. Well, I understand the logistical difficulties, sir. It is an effort to basically facilitate that process rather than create an obstacle.
I suppose you're lucky that I think we do have time. This is, well, if we don't have time, it's going to eat into your time, isn't it, Mr. Poe?
Yes, sir. And as my submissions are for all of Hokianga, and they are supposed to help the hapu of Hokianga present, if there is an incursion, then I'm quite willing to truncate my presentation. I'm getting a ride from Danny to the airport, so I don't want to miss that flight either.
Yes, well, filing these and giving them to Mr. Merito to give to us last night is not the proper way to file things, Mr. Poe.
I understand, sir, so I filed them on the record, and essentially I didn't even file enough copies, sir, because my printer ran out of toner, so there's a whole lot of things that happened, but again, sir, this was
okay.
When everybody's finished.
The claimant is Mr. Wikaira. Is that correct?
It is. Couple.
Mr. Wikaira, this isn't your fault. In fact, far from it. But lawyers have run around, or Mr. Poe has run around at the last minute to try and put something before us. And we'll hear from Mr. Shepherd, and we will, if there are any questions, we'll probably have to put them in writing or seek clarification. Already I note, though, there's no relief being sought. It's an easy claim.
Sir, it is in the statement of claim. There's amended the statement of claim, sir. It's in the amended statement of claim dated 13 June, which was the date of the filing date, sir.
Mr. Shepherd.
I have copies of that if you want, sir.
I've got a copy here.
Thank you, sir. Thank you, sir. Tēnā koe. So the following submissions that I am going to read to close the case in terms of
No, we don't read the submissions word for word, just speak to them, Mr.
I will
Shepherd.
speak to them, sir. But personally, sir, first I'd wish to offer my greatest gratitude to Mr. Wikaira, Mr. Ben Moringa. It's a journey that we started together in 2008, and since this time to have presented evidence in stage 1, military veterans inquiry, and the task of bringing this claim, sir, before this tribunal has often been difficult, demanding for both counsel and claimants. We've both been through our trials and tribulations. But the one consistent thing through this process, sir, is the claimant's mana, knowledge, and aroha to me, something that I'll always treasure, sir. In terms of closings. So you'll see in that document 3.3.307 That's the popo referred to symbolise the pillars of Te Kutu. A lot of the hapu here refer to Te Kutu as the glue. It's also within where the heartlands of Whirinaki sit. Now, sir, it's from within these heartlands that the mana of Te Kutu emanates. This emanation, and you'll remember, sir, that when Te Kutu held the hearings at Hearing Week 8, you were part of a site visit. The evidence of Mr. Anania Wikaira wove that ancestral fabric both to the land and also to the moana. He also says in his evidence here that the starting point for the hapu was from the arrival of Kupe. That their mana and their rangatiratanga, sir, has remained as a people, as part of the people, as part of the environment, sir, and as tangata whenua. The primary issue, sir, is for Te Kutu, it does highlight the corrosive impact that colonisation has had on their ability to maintain the integrity of the social fabric, left and separated from their lands and taonga, vulnerable and impoverished. That has been clear, sir, in terms of the evidence that's been presented by the claimants. I'd like to take my friend's analogy as a death by 1,000 cuts. It's been systematic, and as a result, as today, sir, the claimants have been prejudiced and continue to suffer that prejudice. So fundamentally, that claim, it does set out the erosion of Te Kutu's ability to do what they've always have done, and as they would do. It's according to their central identity and their tikanga, both as taonga tuku iho. Sir, the connections that Te Kutu have in the pre-early European times, and we adopt stage 1 findings, that Te Kutu never ceded their sovereignty. I take that further, sir, in terms of Te Kutu had a direct relationship with the monarchy through the rangatira Waikato, who was essentially the right-hand man for Hongi. That visit, not only to the House of Lords, but also to the King himself, sir, cemented this relationship between the hapu and the monarchy in terms of where they say that they have never ceded their sovereignty and that their rangatiratanga has always remained intact. And sir, there's a number of issues in terms of the filing of the amended statement of claim. The issue that I do have in regards to the native land court process, sir, and I must mention this, it's about Judge Manning. I seek that the tribunal take a precautionary approach when dealing with matters that came before Judge Manning. Sir, he was part, and it was very hard to reconcile at the time. We put Manning on a pedestal during stage 1, and rightfully so. He was vociferous in his opposition to the signing of Te Titi. He had been inducted as part of Te Kutu through the wharewananga process, which was taught at Pūreretahi. And of course, one of the tōhunga there was Papa Huri here. What changed, sir? When you read Armstrong and Sabasic, it's very clear that these sympathies, he married into the Te Kutu hapu, sir, through Moingaroa, who was the daughter of Kaitoke. And so he and Mr. Leff gained their interest through marriages to Arangatira daughter. So he was aware, sir, of the custom. He was fluent in te reo. But then you see him, sir, be elevated to the bench, 1866.
So whereabouts in the report is that?
That's in the amended statement of claim. I've particularised that. But this was also a formative time when the claims were still fresh and a lot of Hokianga's Māori mind, in terms of the old land claims. We had scrip land, sir. We had Crown surplus lands. What was problematic, Your Honour, and it was very hard read for me, and I remember discussing this with Mr. Wikaida. It was clear from the correspondence to von Sturmer, who was later to be a Native Land Court judge as well, of the sheer racism that was involved in that correspondence. What you have here, sir, is essentially a person who rangatira were entitled to prosecute their claims before him. He saw this, and it is in the Armstrong-Sabasic report, as a clear challenge to his authority.
Well, whereabouts in that report?
It's in the statement of claim, sir. It's all been particularised.
But you're doing the closings. You're not doing your statement of claim.
But there's a genesis to that, sir,
You'll be able
because...
to provide that reference?
Yes, I can. But what the issue there, sir, though, is, and it's a connection, it's a causal connection. You have lands here, the land base, the economic base of Te Kutu, taken away very early on from the hapu, put in front of a native land court process that they never consented to, and then in front of Judge Manning, who essentially disregarded their claims. Even himself, sir, with his, and the first native land court location was on Onoki, and you would have seen that, sir, in the site visit when we went on the harbour, Your Honour. Opara, John Leaf's side, on the other side was Frederick Manning's. And that was this location of the first native land court. So there's a causal connection there, sir, from very early on that continued. Even Judge Manning himself, sir, received regular visitors from rangatira in terms of the conceptual understanding of what alienation, and in their minds they never alienated their lands. In fact, there was this, as you see in the Muri Whenua reports here, there's just no concept of alienation, of ownership. Though, in terms of that, sir, they lost access to those lands from very early on. But it's the process itself and what it was subjected to in terms of a person of authority that in my submission, sir, Taraki Māori never had a chance of actually keeping their lands. In fact, Armstrong and Sabasic say that there was no perfect man than Manning to implement a policy of individualisation of title.
Is that a quote or is that a summary of what they say?
That is the actual quote, sir.
You can provide a reference
I
for
can
that?
provide a reference to it, sir. So, sir, we have Manning, and that's why I raised this, we have Manning, sir. Now, there are a number of claimants that have given evidence. Sir, and those were and I'll provide references. Mr. Wikaida, Y1040L18. Mr. Ben Moringa, Y1040L19. Mr. Wynyard, L15. His evidence is really important, sir, because born in 1928, he's the last of his generation to actually be farming in Whirinaki today. He has experienced firsthand, and it complements the technical reports. Especially Rangi Nui Walker. I have the reference here, sir, and that's on transcript of 4.1.13. And it's at page 205, sir. And it starts, and it's in Te Reo, sir. And it's Professor Ranginui Walker. In terms of the interpretation, sir, he says to Mr. Wynyard, do you know what year your father entered the scheme? Mr. Wynyard, no. Was it before the Second World War? Aye. At the time, who was your supervisor? Was it a Māori person or was it a Pākehā? He Pākehā. Because that Pākehā, was he an expert agriculturalist? Answer, I did not know at the time, I was just a young boy. All I know was he was a Pākehā. I know his name is Mr. Latter, and here's in their photo with my dad. And you would have seen, sir, there was a small picture, Marae, of Whirinaki young Māori committee, club, family, the club. And he carries on, sir. Can you tell me where the $50,000 debt, and I'll remind you, sir, that Mr. Wynyard, before taking on the farm from his father, there was a $50,000 debt on the farm. And this is a unit farm that we're talking about. What was that debt expended on? Was it buying stock, fencing, or what? At the time, sir, my father's farm needed work, needed lots of work on it. It wasn't just one facet. But to your father, was he there merely to milk the cow? Aye, aye. But it was the Pākehā supervisor who made the decisions upon fertilising and other matters, and the expenditures thus. Aye. Tautoko i o kōrero. And so in 1962, and this is Professor Walker carried on, you took on the responsibility of the farm, and that debt was placed upon your shoulders. Aye. And 25 years later, you paid that debt, debt-free. Aye. And during that time you struggled to pay your debt. Who had the say on the farm? Who had the say? Kei te supervisor. And there was also the evidence about the veal move. There was always this paternalistic supervision of those that were under the unit farm scheme from the Department of Native Affairs. Intergenerational supervision, sir. And in his evidence, he read about the move to veal from dairy, because, of course, all the farm units were, at the time were in terms of production levels. It says, but you read out about the veal move. You know, I never knew it from him at the time. He gave me no advice about that. And you took that cheque. What did you do with it? I gave it to my wife and daughters to go get things that they wanted for schooling, a new car for us to go shopping, to get food for us, and that left a little piece for me to help me enjoy a little bit of the fruits of my labour. And that debt was paid off. And this is beautiful from Professor Walker. And so the binds of the department were taken off you. Aye. And then so you stood as a man in the world of light. Mr. Wynyard's answer, aye. That complements, sir, in terms of the evidence of this paternalistic nature that Māori were subjected to. And there will be a lot of kaumātua in this room, sir, that were subjected to the same behaviour from the Crown and from the Crown's agent. The other important issue about Mr. Wynyard's evidence is about rehabilitation blocks. It is an amended statement of claim, it's very particularised. The problem, sir, is that there are a number of people on the ground that just never knew what happened to their lands. That's a common theme. People just did not know. Once, before the hapu owned it, and before you know it, there's a stranger on their lands. The rehabilitation block scheme, sir, we're under the unemployment relief scheme. Times were tough, sir. This was at time of the Depression. But they thought, as they were digging up this land, lands that they gathered their kaimoana from, that were awash with mullet, and they dug that by hand, by shovel. Mr. Wynyard was there. His uncles were there. Always on the understanding that they would have those lands. Spade by spade, they destroyed their mahingi kai, thinking that they'd have those lands. And that belief was mistaken. That flows into the issue of the rehabilitation block, sir. Now, you would have seen when you stopped, during the site visit, we stopped at Karuhiruhi. You looked across, and there's a panoramic view of Whirinaki. We looked to the west. On those ridgelines, sir, Taramaroa, a lot of those blocks, good blocks, sir, are now under the Department of Conservation. We are seeking the tribunal for the return of those lands. But the thing is, sir, is there's always this understanding that they were only going to lease those lands. There's a beautiful kōrero again between Professor Walker and Arthur Wynyard talking about this concept, that you go to war, you fight for this country, you come back, you have no lands. There are strangers on their land, sir. It is particularised in the amended statement of claim. Yet, as a boy, sir...
Do you want to get back to your closings, the closings that have been filed? Not your amended statement of claim.
It's all connected, sir, because what I'm saying is that as part of the recommendations that we're seeking is the return of those lands. A lot of those lands are in the management of Department of Conservation. We also seek recommendations, sir, in terms of, and it's connected to the amended statement of claim. We talk about the wish for Tekatu to be autonomous again, that their tino rangatiratanga is again respected. And there is an example there, sir, and you say about the statement of claim, but it is there. The Whirinaki Māori Committee, this is the umbrella. This claim is under its umbrella. Sir, what was the key for the Whirinaki Māori Committee? The key was that you had an umbrella, and it has a whakapapa. A lot of the kaumātua here have been part of that committee. Their fathers, their grandfathers have been part of this committee. It was autonomous. They exercised their tino rangatiratanga over their domain within the claim area. But the key to it, sir, was that it was recognised by third parties. It was recognised by the local councils. It was recognised by the police. And so, that's what I'm asking for, is that we are provided, we are so desperate. You can see the socio-economic impacts that are here. You cannot escape them when you're a part of the community. I hear my friend earlier before me mentioning about Kaitaia and the suicides. We in the north are still considered a backwater. We're crying out for help. The Crown and the recommendations that this tribunal can give can help restore that. My friend talks about youth suicide. The evidence of Helene Leaf, QSM, Forward Services to her community, she is at the coalface. We talk about domestic violence. We're awash with methamphetamine. I deal with it weekly as a lawyer. She also mentions in her evidence about the over-representation of Māori in prison. That's a reality. That's a reality, sir. I still believe, as a criminal lawyer, that someone's freedom is a basic fundamental human right. Yet, I see twice weekly our people going to prison.
You're not giving evidence from the bar, are you?
Absolutely not.
Well, then what was that?
Well, sir, what we're saying though is that...
Do you want to get back to your closing?
Well, what we're saying, sir, is that we wish...
Stop, Mr. Shepherd. Do you want to get back to the closings that have been filed and take us through those?
What we wish, sir, is to not be the ambulance at the bottom of the cliff. We need to be at the top. So in terms of what I've said, sir, is in these closings, it talks about the consolidation schemes, the delays, the socio-economic impact, the poverty because of the delays. Over a generation, sir, from once those lands were incorporated in the schemes, over a generation before those binds were removed. Ties in, sir, with the Crown closings, with the claimant closings, in terms of the inadequate medical facilities, the inadequate Crown's delivery of health services to Māori, not only for Tūketu, but in Hokianga and for Taraki Māori. We are at a point, sir, that the average wage is the rate of a benefit. That there, because of this loss of economic base, that a number of the claimants, our people, are state dependent. We wish for this tribunal to make strong recommendations. You'll see, sir, that in terms of the closing at Paraoa 25, Northland does have the highest unemployment rate, nationwide. There's a lot of factors in that, sir, in terms of unemployment. Young people, people with criminal convictions, essentially become unemployable. I've never seen so many young people on the streets, sir, that can't get a job. We also talk about the assimilation of education. Two schools of thought, Your Honour. The traditional way of Professor Tutuhi Robust. He has so many letters behind his name, sir. It's a credit to him. He's gone through the traditional method in terms of having to leave Whirinaki to get a tertiary level education. And then, of course, you have the evidence of Claire Papuni. Kura kaupapa Māori. The essential teachings, sir, of where the child is the centre, but there's this buy-in from the community, from the whānau, from the hapu. She, though, even that, sir, is subject to Crown controls. It is funded by the Crown. They still are assessed by the Crown framework in terms of education. It is a cumulative effect, sir. It is in the statement of claim. It has started with this tribunal, sir, in terms of the stage 1 report findings. But here we are in stage 2, sir. You can make recommendations to actually bring back the economic power base of Tūketu, to return their lands, to actually, as in Isabel Dalton's and Lynette Wharero, they're kaitiaki of their own environment. Environments, sir, that they've seen denuded, polluted. In Ms. Wharero's evidence, she talks about these boundaries that are put on Te Kutu. Boundaries as from the health boards, boundaries from this claim inquiry district, sir, as an example. It is holistic. They talk about not just being tokenistic, but really talking about the principle of partnership. As an example, Sir, Te Kutu's also filed a claim under the Takutai Moana Act. What it shows, Sir, in my submission, is that there's still that Crown attitude. That here the claimants have to prove a customary right. A customary right, according to the legislation. What is problematic, of course, in that legislation, sir, is the concept of full and exclusive right. That's problematic, sir, because as you all know, through your travels and listening to the hearings, we have a number of hapu that share those resources. This whanaungatanga, this is still the Crown individualising Māori, but in an environmental sense. It must stop, sir. And I can say this, sir, is that you can make recommendations to allow Te Kutu to be the power base that they used to be from early on, from pre-European contact. They were at the forefront, Te Kutu. Let them have that economic power base again, so they can look after their own people, sir. So they don't have to depend on the state, because it can work, Your Honour. It can work. They can look after their own people. Give them the resources. Give them the respect to allow them to do that too. Kia ora.
We have no questions, Mr. Shepherd. I would ask that you file an amended closing statement, and I'll put that in the post hearing direction.
Thank you.
And include references and the like.
Absolutely.
Mr. Wynyard.
Arthur.
Hello, everybody. As you don't know who I am, I'm Arthur Wynyard.
All right.
I'm sorry I come in a bit late, but I've come in and heard enough to support what Tony has said. Now I could go and elaborate a bit more about things that are happening with us. Now, before I go any further, I'd just like to say this. I give Tony the right to use my kōrero and take it as far as he can, if it would help us.
Yes, and Mr. Wynyard, we have all that kōrero on our record. We have your brief of evidence, and we have the statements. Tēnā koe.
And I don't know, yesterday I was working on my farm, still work on the farm, and I never even thought I'd be here.
Tēnā koe.
But late last evening, one of my mokos rang me and said, "Koro, Matua, are you going to listen to the kōrero tomorrow?" Then the penny dropped with me. Something told me I had to come today. And then they said I had to leave at 5:30 this morning. And I was up at 4 o'clock. I was that excited to be invited to come. But all I want to say is to everybody that's gathered here, I support what Tony has said, and I wish I could say a lot more. that's happened in my lifetime. The saddest thing to me is that I've grown up in Whirinaki all my life. And the history, I've got it all. Many people have come to me and wanted the history, but it's preserved. But this is the place to put it out when it's needed.
Yes, and we thank you for the kōrero that you have provided, Mr. Wynyard. And
anyway, I won't prolong my kōrero any longer. But I'd just like to, the last comment that Tony has made, you know, we in Whirinaki, we're strong. We're very, very strong. Hapu.
Kia ora.
And the saddest thing to me at the moment, we're all broken up. You know, we're in little groups, striving to exist. Me, for one, I've farmed all my life, and I'm still farming. And I can take any one of you out to my farm and the hard work that I've put into it. And I'm still doing it today. I'm retired, but I'm doing it for my mokos.
Tēnā koe.
They're the ones that need it. And I wish everybody was like me.
Ko mātou tēnei, te kutu o hoki anga, whakapau karakia, i runga o whiria, pai aka o te riri, te kaora riri, au e te aroha, au e. Mai kei te wai, me ko ai mātou, he uri nora hiri, taura mō ko i runga, tuku i ho mai rā, e mahu mātou, au e te aroha, au e, au e te aroha, au e.
Kia ora koutou. Kia ora koutou.
Kia ora, sir.
And that takes us to morning tea, and we'll be back at 11.
Ko mai ngā tani whā te maunga, ko manga muka te marae ngā puhi, te whare hoki anga te moana ngā puhi, nui tonu te iwi e ngā reo, e ngā mana e ngā kāranga ranga maha, nau mai, haere mai. Tautoko.
Ai nau mai hara mai e hoa mā ki tēnei ngā wahanga whakamutu mō tātou mō tēnei rā ko te rau hakamutunga mō te kaupapa nui i mua i ngā hapu me ngā whānau. Raro te kaupapa o te paparaki o te raki me rātou te ropu whakamana i te trite o Waitangi. Kei konei mātou mai te reo takiwā nei mō tēnei wahanga mutunga mō tēnei wiki, ko te wiki rutikau mā whā. I te rā nei, ko rongo tātou ki a rātou, ko te tuatai ko Onero Pihima, ka tuku ia te pitiana i mua hoki i a rātou, te ropu whakamana te trite o Waitangi, me rātou hoki ngā whānau mai kua te taka me ngā whanunga hoki mai Ngāti Kiore. Ai taina ko rongo tātou ki te kororo mai te hikutu ngā whanunga mai raro te maunga rā ki te rata o te awatapu o hokianga nei, ko te rama roa, ko te hikutu tērā, ko rongo rātou ki a rātou mā. Hoi anō, ka mihi anō ki kia koe, noha mai nei kui tō tātika. I tēnei rā, tino pai ka whiti mai te rā kei kone, kei whāngare nei, anō tēnei broadcasting live. That's week 24, last day of the closing submissions. This morning we heard from Barney, who represented Onero Pihuma, who served the Crown with a notice of trespass for treason, high treason, and something that's has been talked about in the past and mentioned in previous Waitangi tribunals by Dr. Ranginui Walker. There has been much kōrero internationally about high treason for the various governments which have assumed their rangatira tanga over the various iwi taki o te ao. So a very important take, and one that of course has been new to this process. As well, we had Hōdi and Barney represented Hōdi on the issue for Koatutaka and Ngāti Kiore, who maintain that they have not ceded sovereignty from 1842 until to today. And there's been many actions that have been led by that particular hapu for many, many years, from the incarceration of their tupuna for reoccupying land in a place called Omakura. There have been many times and stories from the old people of Mangataipa who lay on the road when the council came to desecrate Urupa, to desecrate and take a roading, land for roading. So there have been many instances of the assertion of rangatiratanga for Ngāti Kiore and Koatutaka, but as well our whanunga from Te Hiku too. And this week has been quite a difficult week for many of the claimants. It's been mainly the lawyers who present the evidence, and at times it has been quite challenging to be able to listen to the kōrero within a legal framework. And I was reminded the other day by one of the lawyers that this is purely just another court set up under a tauiwi, tikanga tauiwi, and going through a tauiwi legal process. So there has been talk about the international forum and what is available for our First Nations people of Aotearoa to look at going beyond this process. We know at this time there's also the government is wanting to get a full and final settlement from Ngāpui. So there has been lots of work for that to happen. And more recently, the Prime Minister has said they wish to pull out of the process, and it's time for Ngāpui to sort out Ngāpui. And so there's been lots of whakaaro shared about where to from here. What happens once this process finishes? And we all know that our whānau back on the Haukanga are still confronted with many issues as a result of the inability to maintain our rangatiratanga back on the home front, the laws that have impacted on our ability to control our people and to deal with our local issues and all those important things. So again, it's been great being with you this morning. We've got a 15-minute break. Back with you in a short time for this, the last day of the Waitangi Tribunal Hearings here in Whangarei, Stage 2, Week 24. Ngā mihi nui tēnei kia koe. Terenga Paraoa Marae Whangarei, te paparahi o te raki, wiki rui te kaumā whā. Te ropu whakamana e te triti o Waitangi, te mana motake arohe o Whangarei, iwa i tata, taino ki te rima kraka i te aihi, mane te kaumā iwa tai atu ki praere rui te kaumā toru. Tautoko, broadcasting live from Terenga Paraoa Marae, te paparahi o te raki, week 24, the Waitangi Tribunal Hearing Stage 2. Monday, 9 o'clock until Friday, 5 p.m, here with your Tribal Connection.
Kanganga hukua ti horetera Kanganga huka anganga araie Koe hinga poke au whakakapo Kamarama mahe a te rangi paki Kamarama mahe a te rangi paki Aikataya kare e mamai e oe Kungaro nei te pori te aroha Anei te kopere e noi tianei Kamarama mahe a te rangi paki Aro ake kua paki katoa Roki mua kua paki Kanganga hukua ti horetera Kanganga huka anganga araie Koe hinga poke au whakakapo Kamarama mahe a te rangi paki 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 Kamarama mahe a te rangi paki
Kamalama, witi mai te malama tākiri ko te ata kore I ko te manu. Ko te manu korori, ko te manu korora. Kore no te amai no te awakarere. Aire rā I te pō, nau mai e te ao. Mā te reringa o ngā kōri pori kua te wai tapu e waka pūri o te rangi waka e te. E te o, e ura, e au uti e mauri ora.
Takiri ko te ata kiru ngā oru a peu I ana mai ata manu I te rā I te pairangi Korihi ko te manu I te ngutu o te wao He rā anō kua ua mai
O ake maranga mai tika roia o tore tore Te o ona ake Are are mai o taringa pa uri tia mai Ki te ohonga ake
Takiri ko te ata kiru ngā oru manu I te rā, I te pairangi. Korihi, ko te manu I te ngutu o te wao. He rā anō, kua ua mai. Te nganga huku a ti hore te rā. Ka nganga huka, a nganga arai e. Ko wehi ngā poke au whakakapo. Ka marama, mahe a te rangi paki. Ka marama, mahe a te rangi paki. Ai ka taia kare e mamai e aue. Ko ngaro nei te pori te aroha. Anei te kōpere e noi tia nei. Ka marama, mahe a te rangi paki. Aro ake, kua paki katoa. Roki mua, kua paki nganga huku a ti hore te rā. Ka nganga huka, a nganga arai e. Kua wehi ngā poke au whakakapo. Ka marama, mahe a te rangi paki. 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 Ka marama, mahe a te rangi paki.
Peke ki te matou, peke ki te maui, alright. Peke ki te matou, peke ki te maui, oh yeah. Peke ki a koto ngakau, peke ki a tino hari koa ko ngakau. Peke ki a koto ngakau, peke ki a tino hari koa ko ngakau.
Ahi creamy waka hohoro, where I te mo wana neke. I move it to the left, I move it to the right. Peke ki te mato. There's some ice cream, there's some really fast cars. Hot on the beach and I'm eating Mars bars. Peke to the left, peke to the right.
Peke ki te matou, peke ki te maui, alright. Peke ki te matou, peke ki te maui, oh yeah. Peke ki a koto ngakau, peke ki a tino hari koa ko ngakau. Peke ki a koto ngakau, peke ki a tino hari koa ko ngakau.
Ahi creamy waka hohoro, where I te mo wana neke. I move it to the left, I move it to the right. Peke ki te mato. There's some ice cream, there's some really fast cars. Hot on the beach and I'm eating Mars bars. Peke to the left, peke to the right.
Peke ki te mata, peke ki te maui, alright. Peke ki te mata, peke ki te maui, oh yeah. Peke kia koto ngakau, peke kia tino hari koa ko ngakau, peke kia koto ngakau, peke kia tino hari koa ko ngakau.
Ahi creamy waka hohoro, where I te mo wana neke. I'm moving to the left, I'm moving to the right. Peke ki te mato. There's some ice cream, there's some really fast cars. Hot on the beach and I'm eating Mars bars. Peke to the left, peke to the right.
Maunga ki maunga, tai ki ngā tai, tō reo I rangi, tau toko FM.
Kua ngaro koe I te atarau, I hinga iho I te pō, titiro ake ki te amu.
Particular claim and have supported the individuals through this journey and who are no longer with us, and that includes the late Mere King, Rima Edwards, John Rogers and Iparaima Hauraki. Turning to the submissions at hand, Your Honour, Council is aware that this tribunal already has a significant amount of evidence already before it that traverses much of the issues relevant to this particular claim. So today I would like to focus these submissions on the degradation of the claimant's lands, waterways and resources as a result of the imposed management scheme, particularly under the RMA framework. The relevant treaty principles have been identified by the claimants where they feel that are particular to their claim, and that's detailed through paragraph 19 from A through to H. The claimant's ability and right as kaitiaki to care for these taonga have been removed and vested into local authority bodies, and these authorities have been created through Crown legislation. Under this Crown-imposed regime, their most important and treasured taonga, their maunga, their awa, their marae, have all been desecrated, polluted and defiled. What is most pertinent to the claimants is that these are not just historical issues, rather these are real struggles that the people of Omanaya face to this very day. Now, the structure of the closing submissions, Your Honour, have reflected the amended statement of claim and have extended upon that particular document. But notwithstanding the fact that the statutory framework to which the local authorities are bound by contains strong cultural directions which, as the Privy Council has already ruled, must be borne in mind at every stage of the planning process, the realisation is that none of these provisions actually provide an absolute requirement for those authorities to actively protect these taonga and to meaningfully interact in good faith and in the nature of partnership with the claimants. As this tribunal has heard, under Part 2 of the RMA, Sections 6, 7 and 8 hold such cultural directives which are meant to provide the pathway to protect the claimant's interests. However, the reality for the claimants is that the mechanisms that govern such controls have harsh consequences on the claimant's interests, and that participation in this RMA framework, be it through a resource consent application process, through a regional and district plan engagement process, are extremely bureaucratic and require substantial time and resources. Not only that, it also requires an in-depth knowledge about the land assessment mechanisms that are built into those particular instruments. The claimants do not have sufficient resources to adequately participate in the number of issues involving their rohe, And when the claimants do participate, the protection afforded under the Crown schemes are grossly inadequate and do not protect the claimant's rights as guaranteed under Te Tiriti and its associated principles. As a consequence of these prejudices, the claimants are unable to exercise their own mana and kaitiakitanga. It is Council's submission that the Crown has failed to provide absolute recognition of their rights. Instead, the Crown has watered down the principles of Te Tiriti to be a mere consideration under the resource management framework. Council does acknowledge the Crown's recent introduction of Section 58M of the Resource Management Act to include iwi participation agreements or mana whakahono arohe arrangements. This section provides an opportunity for the claimants to participate in resource management and decision-making processes under this Act, but it's also an opportunity for the local authorities to comply with their statutory duties provided under the Resource Management Act. However, this section still falls short where the powers that the shared power arrangement that the claimants like to aspire to still lies with the local authority body. So the authority ultimately still has that final decision on whether or not to engage with any of environmental planning processes that they may see relevant to their particular claimant area. However, it seems no matter how important these cultural directives are, these Māori interest-based considerations still need to compete for the attention of the final decision maker against a multi-layered menu of other interests. It is the experience of the claimants that these cultural directives are easily set to one side in pursuit of a Western view of sustainable management, as it seems to be the preference of the relevant decider in the claimant's rohe. This is clearly demonstrated in the claimants' continued fight to protect their maunga from the devastating effects of quarrying activities and the absent and continued lack of engagement in regards to consultation in the continued granting of that resource consent. The result of this regime forces the claimants into a process where they are constantly being asked to define and prove their connections to natural, cultural and spiritual values on the environment to a Western cultural society that is forever trying to find ways to exploit their resources, their ancestral lands and also their waterways. Most times the claimants aren't even afforded this respect to even define those connections. Again, this is demonstrated through the continued granting of the resource consent for the Mangawhero quarry. For the claimants, it is not surprising that the relationship with the local authorities is at times significantly strained because of the failure of these Crown agencies to give effect to recognise and provide for, or even simply to take into account the strong cultural directives such as the principles of Te Tiriti within the Resource Management Act. The absence of consultation by the local bodies with the claimants has seen their most treasured taonga, their marae, te piti, defiled. And this was a consequence of the construction of State Highway 12, where the local authority diverted the Omanaya River near te piti. There was no discussion or consultation with the whānau concerning the realignment of the road or the diversion of the stream itself. As a result, the natural floodplain has been affected so badly that when it does flood, it completely cuts off access to the marae, unless you have a boat. The flood waters have resulted in internal flooding of not only their whare tūpuna, but their whare kai, their whare paku, and their kohanga building on the marae. Now, the claimants have unwillingly paid a tremendous price with their ancestral lands, waterways and resources in the establishment of the Rawene township and local economy. This contribution has at times been made willingly, but by and large this contribution has been made through the imposition of Crown laws and policies. From a natural resource viewpoint, these include, but are definitely not limited to, the land reclamations, particularly the Ohuri Flat and Rawene reclamation, the Rawene water supply, and here the claimants demonstrated their aspiration to join in a mutual arrangement for the benefit of the local community, where they agreed to allow the Whai North District Council, or at the time the Hokianga County Council, to draw from the Pētaka stream for the mutual benefit of the community by supplying water to the hospital, the Mangawhero quarry and the dumping of sewage sludge on their taonga, the defilement of their wāhi tapu for the purposes of a sewage pond, for sewage ponds for the Rawene Township, and the Rawene wastewater treatment plant, and the defilement of the Hokianga Harbour and their waterways by the discharge of contaminants into those areas. As the technical evidence is noted, the system of management of the resources imposed by the Crown has promoted exploitation of these resources over preservation of these resources. For the Crown, other objectives such as economic prosperity and farm development were more important than the environmental consequences. This has caused irreversible damage to the ecosystem and the environment and the indigenous flora and fauna of the claimants. In regards to the breaches of the Crown has delegated the management of these resources to those local authority bodies. The delegated management has failed to protect the waterways, maunga and other resources, and has failed to protect the claimants' interests in these resources. The Crown has denied the claimants' right to control, manage and regulate any activities in relation to those resources, and the Crown has denied the claimants' ability to enforce or to adequately enforce their rights and mana over their resources. Now, in relation to relief being sought, Your Honour, prior to the evolution of the treaty principles, the claimants submit that an authentic shared power system should have supported the coexistence and well-being of both parties, treasuring what was already in existence for both partners and collaborating on matters that fell in between. What eventuated, as we know, was far from ideal. However, this ideology is something the claimants are still wanting to aspire to, and they turn to this tribunal for findings and recommendations that will achieve this outcome. Page 101 of the closing submissions, starting at paragraph 417, outline the relief that the claimants are seeking and today have not diverged at all from those reliefs that is being sought.
Taihoa, this is 101. Okay.
If the tribunal have no questions, those are the submissions.
On the resource management issue?
Yes.
Taihoa, any questions on that? We may have questions, and then we may be putting some questions to you in writing. We have no questions at the moment. Proceed.
Thank you, sir. That's all.
Is that your...
That's all, sir.
Okay. Taihoa.
Actually, sir, before I do close off, I would like to actually call upon Mr. Korewha to close off the submissions for Ngāti Hau, me Ngāti Kairau.
Can I just ask, because you make a point, just at this time, you make a point, and others have also made it, and I know the tribunal has said on a number of occasions the position of local government. I mean, the Crown said local government, they're not the Crown. And I note that in there you said it's the Crown has delegated management. Have I got that right?
That's correct.
So what's your view in terms of local government? Are they part of the Crown, or the Crown still has responsibilities and obligations?
So it's Council's submission that it would be extremely difficult to try and separate the functions of a local government authority from the Crown. The Crown itself created this body under the Local Government Act, and even though they have allowed delegation of powers to come through those particular agencies, the government still has a responsibility to the claimants to ensure that the te tiriti principles that they have has evolved through common law or other processes, that those bodies give effect to those principles.
So it's not that the local government is part of the Crown, but the Crown must ensure that the local authorities act consistently with the consistently with the treaty.
Absolutely, and the Crown have acted, have provided mechanisms through national policy statements that require local bodies to give effect to protecting the environment, whether it be the coastal environment area, but how they are required, that body is required to give effect to that national policy statement. And mere recognition or consideration of that national policy statement does not go far enough, and that common law is well established in that area, that local bodies must give effect to that mechanism. So whether this tribunal will be willing to make a recommendation on providing a tool such as a national policy statement to direct these bodies to give effect to the principles, potentially may be an effective tool to make these bodies accountable to the responsibilities of the Crown.
And my last question is, a number of submissions have said that they want a recommendation from this tribunal that the Crown, in consultation with the claimants, institute constitutional change. And we've had varied views about that may be recognised through hapu authorities. What are your clients wanting in terms of the constitutional change? Or is that to be, the first step is actually getting to the table and having that discussion, is it?
Absolutely. I think the claimants have always known what their I suppose their constitutional arrangement would look like, and as I mentioned in my closing, that in their mind was aspired to be a shared power arrangement. I'm going to leave it to my co-counsel, Mr. Poe, to extend on that constitutional relationship, but I do believe that at hapu level it does need to start in regards to how that relationship can begin to grow.
So just on that, I just, in a Ngāti Hau, Ngāti Kaharau context, recall the evidence of Rima Edwards, who gave evidence around the power sharing that he saw and the relationships that he saw might exist. I mean, here's a kaumātua of Ngāti Hau, Ngāti Kaharau. He talked about potentials for upper houses, but it was...
Yes, Dr. Gillian spoke about this yesterday.
Yeah, so those sharing arrangements, those are the mechanisms that are contemplated within the aspiration of Ngāti Hau, Ngāti Kaharau. I will develop this in the overall submission, but the submission around constitutional change is made. It's a pragmatic approach. In my submission, it's a process outcome. It's not asking this tribunal to recommend everything be turned over on its head, that the world change and we're left with anarchy and try and figure out what that relationship is. But there does need to be a process to be effected which recognises the status of tangata whenua in this country. And it's that status that's the important thing, the status that's reflected in te treaty, as opposed to the status that exists now. And I guess it's about it's about creating processes that will correct those, that imbalance and that improper status, that exists now that wasn't contemplated in Te Tiriti.
Thank you, Mr. Poe.
Before I do close, I would like to ask Mr. Koriwha to have the final say for the claimant.
Yes.
That's all right.
Ka tira te whānau. Tēnei tūake oku, mihi tuna ke kia tātou I roto I tēnei o ngā tupuna whare. E ngā hapu katoa, e ngā mātua katoa, e te hoki anga e koutou e ngā mātua. Nā, tēnā koutou ko hara mai ki te hakanui tēnei kaupapa o tātou, tēnei kaupapa hira. Nā ka mihi tuna ki a koutou e ngā mana whakahaere. Nā, me pēnei ana, e poto noi ho tēnei kakau oku. Nō reira, me pēnei ana, nā, e rapu anau taku tuakana. E taku tuakana kei hea koe. Yeah, I need to speak to you, my older brother. You know, I've been brought up to you know, because I don't give a lot to a lot of English words, but two words that I've certainly grown up, please and thank you, get you a long way, boy. You know, and then when it comes to mergers and partnerships, these other two words that come up, honesty and integrity. Hey, and I mean, you don't have to be a rocket scientist to get at it. Angatu tēnei hoiho ki hea. Hey, rapu anau taku tuakana. My big brother that was left to look after me, keep me safe, you know, from all these atrocities of, you know, and here we are. I'm having to dignify myself and explain myself to you, my big brother. And you're supposed to look after me. Nē, nā me pēnei ana taku kōrero kia koutou. I mean, for those of you, I mean, I have to put this in English because it's the English and the Māori that sort of got us here into this predicament that now we're fighting over words and understandings. So, as a closing submission to Ngāti Kaharau me Ngāti Hau, hau ngā no ki tēnei kōrero katoa e tuhingia ki runga I ngā pepa nei, I can only reiterate what our nannies, I mean, you know, for Māori, Māori got a lot of echoes. We all got echoes, People echo to us all the time. We got all these reiterated things going on by people who have lived before us, all our tupuna and all the people who have whakamana all of this, all of their talk, you know, echo to us all. And for my people, they say to me, boy, all we want to be the mana whakahaere. We're talking about Ngāti Kaharau, Ngāti Hau ki o manaia in our riu, in our awa. Yep, they just say, we want to be the mana whakahaere. Te rangi me te whenua ngā mea katoa ke wainganui. That's all we want, boy. That's all we want. Ka mutu. So, you know, after all this, that's basically all we want, is to be the mana whakahaere of our lands, our rivers. It's not a big place. It's not a big place. And I'm not talking about the vested interests without te mahurehure, without te hikutu, without tupoto and you know, with our surrounding hapu, but yes, we just want to be the te kōrero timatanga, te kōrero hakamututanga mo mātou o Ngāti Kaharau, o Ngāti Hau ki roto o manaia. No reira, e tātou mā, e ngā mātua katoa, even though this, I doubt if this, you know, this is supposed to be the final, but is there such a thing? The other day we had a hui at home, tikanga hui, talking about the tikanga. What does the Tūturu Māori look like in 2017? He's got a car, he's got a house, he's got a phone with G4, with all the, you know, got a million times more things that you used, the knowledge you used to get on the moon, and look where our kids are, they're playing with all these things. And here we are, 177 years later, and we are still giving you the benefit of the doubt, big brother, that we can make these things right. Kia pono, kia tika te tangata ki roto e nei mahi katoa. Nō reira, e tātou mā. Koutou katoa e haka mana nei re nei katoa, e tātou, tēnā koutou. Tēnā koutou. Kia ora mai ino tātou. I roto I tēnei whare, ka te ngā te
Hei, kei te kōrero te tangata nei. Kia ora. And just like to acknowledge the claimant's former lawyer, Judge Armstrong. And he'll give you feedback on how well you did later, Ms. Neems.
You'll note that the corrections that she made to the statement of claim that was filed by Judge Armstrong, Sue. So,
Mr. Pope.
Within the words of Buck, o Tāpiki Korewha, who's just spoken before me, Sue, I was just having that discussion with you about constitutional change. And I thought it was quite an eloquent prayer for relief that he made, that they want to be mana whakahaere over their rohe, and over the taonga that exist within their rohe. And that issue is about status. It's about their status to be, exist, and to be kaitiaki within their own rohe, unfettered and unshaped by what others might think that exercise of kaitiaki tanga looks like. That's what these claims are about. These claims are about the status of hokianga. If we go to the first page on the submissions that were filed, I'm not sure what the number is.
3.3.297A.
A, yes. Now I start there. Now it's an English translation of a quote from Mohi Tāwhai. Let the tongue of everyone be free to speak, but what of it? What will be the end? Our sayings will sink to the bottom like a stone, but your sayings will float light like the wood of the faux tree, and always remain to be seen. Am I telling lies? That's exactly what's happened. The words, the Māori version of the treaty, the promises that were in there, the understandings of Māori have sunk like stones to be on the bottom, and the understanding of what that relationship will be or should be has been reinterpreted in a series of lies, I would submit, to legitimise the exercise of authority by asserting a consent that was never granted. This is really important because I, unlike a number of the lawyers that have made submissions, my submission is that the te treaty signifies a relationship of some kind. So it doesn't signify mutually exclusive spheres of influence. It signifies spheres of influence that will assist each other. But what my submission is that the power that vests within those spheres of influence needs to be looked at in terms of what was consensually accommodated in terms of te treaty. And I don't want to say granted or given, but what was accommodated in terms of the governor's presence and his role to manage his people and facilitate the aspirations and well-beings of Māori in the exercise of tino rangatiratanga for themselves. So on the first page I set out just some formalities, some of the claims that are captured by this closing. And I note on the next page the approach. Now the approach is to have all these hapu claims read together and highlight particular issues that affect them. I don't want to go retraverse the generic submissions that have been made. And look, I've had a long thought about a lot of the generic submissions that were made. A number of other counsel have come before this tribunal and rejected parts. I'm not going to do that, even where they might be inconsistent. Those inconsistencies in themselves are reflective of the fabric of Ngāpuhi. And they are reflective of the different understandings that do exist and the different approaches to the maintenance of tino rangatiratanga that existed throughout te paparahi o te raki as a whole, and reflective of that whakatauki, ka mimiti te puna o tau mārere, ka tō te puna o hokianga. And the other thing is, when you start separating them into hapu and looking at the issues that have afflicted the particular hapu, you see the same things happening and the same prejudices. So it's a redundant exercise saying it all over. But what you do see is you see where they were joined together, you see them separated out or pitted against each other within processes that were imposed upon them and placed to determine how they could exercise rangatiratanga within their region. Now, at paragraph 6, I think it's important to take the tribunal to here. It's not the intention of these submissions to gild the lily and suggest in any way that there was never conflict amongst the whānau and hapu prior to 1840. But if you step back and have a look, the hapu are all one big whānau. They are all related to each other. So when you look at this, and Patu Hohepa says it quite well, is you can't take the hierarchical approach that exists within the rest of the country and say he iwi, he hapu, he whānau. Sometimes the whānau is bigger than the hapu. And the exercise of rangatiratanga occurs at every level. So when you pit a hapu against a hapu, that's not necessarily two distinct polities. That's a whānau going up against each other. As you would have seen in the Arawhatatotara block, when you have mohi tāwhai on one side and you have Wirumu Pāti on the other side, they're the same family. But they're there representing different issues, having a fight, and the systems that were placed engendered that fighting and that fragmentation, because it put at its forefront the determination or the redetermination of interests in a way that the Crown wouldn't see as so repugnant to its interests in terms of a colonial objective. And I set out there at paragraph 7, Mohi Tāwhai, born in Utukura, he was te ngahe like Auntie Celia Birch. He was also Māhurehure. If you read the statement of claim from Ngāti Hau, Ngāti Kaharo, he's also Ngāti Hau, Ngāti Kaharo. He's also Te Hikutu, and that's the relationship that goes through. We are all a whānau. So when Professor Hohepa talks about the political entities that exist, he talks about them in terms of that whakatauki ko whaorau. How we exist in our own holes, but we are allowed to migrate to different holes and share holes and work together in a way that frustrates each other most of the time, but in a way that is uniquely Ngāpuhi. And each one of those holes is unique in its own self, and needs their uniqueness needs to be reflected in some way, but not in a way that separates them from the holes that they lie alongside. And I think most graphically, again, relying on Professor Hohepa, he referred to those holes as the holes in a kupenga, the nets that are there, and every hole provides an opportunity rather than every hole providing something that will that becomes difficult to surmount. And in that way, under paragraph 10, Professor Hohepa notes that our past is in front of us, our ancestors are there, and our protocols, tikanga and kaupapa, come from them, and our genealogy. It's these sorts of things that have been fragmented over time and frayed. So I list the witnesses that have given evidence there for these claims in particular. Now those are the ones that basically that have come in under these numbers, but these submissions rely on all of the evidence that's been given for Hokianga, within Hokianga, or impacting upon Hokianga, even the ones we don't agree with. I've personally cross-examined one of the witnesses at Mātai Taua around the relationship between Te Popoto and Ngāti Toro. But that's their kōrero. Ngāti Toro's kōrero is Ngāti Toro's, and Ngāti Toro's kōrero needs to be respected in its own way. Same way that everybody else has to be respected, but in terms of that one big family. And what's, I didn't put it in the submission, but I did have a look at the people who signed the whakaputanga. A lot of brothers and first cousins. Again, highlighting the fact that it is one big family who are working together to try and exercise rangatiratanga. Now, where I've got the context, I set out the context of these claims, and again, I've talked about how Professor Hohepa talks about the individual core whao and those sorts of things. Now, yesterday he showed me a report that he wrote with Dr. David Williams in 1996 regarding to tikanga as it relates to succession. It was a law commission paper. Taking into account of te ao Māori in relation to reform of the law of succession. The interesting thing is that everything that he says in there, he says in his evidence. So he's been consistent. Ngāpuhi are consistently inconsistent. But it's an important thing to make out because we aren't just trying to be different for different sake. We aren't coming here and saying we're different because we want to affect a different settlement outcome. We want a different settlement outcome if we're going to get a settlement outcome because we are different. I think that's something that's really important to keep in mind in terms of the expression of ourselves as hokianga in support of Ngāpuhi. Our way of doing things is unique, and the systems that have been put in place, even some of the systems that have been put in place to assist Māori, by the way in which they template and create hierarchies in themselves, create their own particular forms of prejudices. And when I get to the education system and talk about the works of Ipu Absalom and Arapera Ngaha and Marara Rogers and also Ruth Hills, who gave evidence for Te Popoto, we see these hokianga women. They are all hokianga women. Oh. And you, Pat, though, and you, Pat, not just women. All these educators that have come back, but that have devoted their time to try and provide something that's culturally responsive and uniquely responsive to hokianga. And this is an important thing because they've tried it, they've shown how it can be successful, and they've shown ways forward. So any suggestion from the Crown that those sorts of mechanisms would be unrealistic, you're being unrealistic, hokianga, to ask for something that's different to the rest of Māoridom. Hokianga, you're asking for something more particular than Ngāpuhi. Well, Ngāpuhi are huge, and we deserve something particular for us. And hokianga are huge, and we are the birthplace of hokianga. So we do deserve something special and something reflective of the status that we should be afforded as a result of the promises that exist within Te Tiriti o Waitangi. Now, the rest of that context, I essentially summarised when I got up, was it the day before yesterday, and talked about uia te pātai and how te kawa o Rāhiri binds us. It's our karapoti that weaves us together and unites us, even at times of strife and when we are fraying. It's what makes us strong as a whole. When we talk about hokianga, even that, though, is a dynamic thing, and we can't say this is the hokianga approach all the time. And perhaps I'll touch on it in the Northern Wars, but te ihutai are part of hokianga. They fought alongside Hone Heke against hokianga in the war. So within that, you get the realisation that the way in which the democratic society of hokianga worked wasn't necessarily a tyrannical process where rangatira just dictated what was going to happen. What does happen in hokianga, and the tribunal's probably seen this, is when you tell somebody to do something, that's when they really want to do the opposite. And it's exactly what was happening in terms of that relationship with Te Ihutai at that time. But again, that unique way of doing things is the hokianga resilience. It's what holds us together. It's how we have been able to maintain our culture in different pockets, relying on different places. The ngākahi from Omanaya and the tohunga that existed within Otaua that were talked about by whakatau kopa. And those sorts of things, they've been able to be protected in pockets even while other hapu or other holes have been ravaged by the strictures of colonisation. And I think that maintenance of te kawa o Rāhiri is the overriding thing. And I think it's important to recall that submission that was made by Patu Hōhepa Tautehie in terms of looking at those spheres of influence and how they work together. And what power or what authority was expected to emanate from within those spheres. What's clear is that the promises within Te Treaty do not evidence a consent from Hokianga Rangatira for the power that exists within the sphere of kāwanatanga to be imposed over them in a way that would constrict them in the exercise of tino rangatiratanga. What they expected was that that power that would be accommodated within the exercise of kāwanatanga would be exercised in a way that would facilitate them in the exercise and expression of their tino rangatiratanga. Now, this might be jumping around a bit, but I do want to touch on that question that you asked Ms. Neems around the local authorities and those sorts of things, because that actually is a contemporary issue in terms of where these spheres rub up against each other. If sovereignty wasn't granted to the Crown by way of the treaty, then the Crown can't delegate what it wasn't given. The treaty principle is the delegation of authority cannot occur in a way that breaches Te Treaty. If you grant what you weren't given, you're breaching Te Treaty. The actions, the works that are done by the local authorities are functions of the Crown, and even if they aren't deemed to be absolute functionaries of the Crown, they are deemed under the Resource Management Act as functions that carry out Crown acts in terms of the sustainable management of resources in this country. So the functions that they are given to them by the Crown. Now, if the Crown have given them more authority than they were supposed to have, then it's a case of nemo dat quod non habet. You can't give away what you don't own. And in that sense, it's a breach. Those local authorities, and going back to the signing of Te Treaty, given the fact that the Governor signed for the Crown, there was an expectation that there would be some sort of delegation. But what could be delegated necessarily has to be a subset of what was achieved. So in this sense, Sir, it probably would be good to have a discussion about the principles of the treaty, given your overriding jurisdiction. My submission is that the principles of the treaty are valid in the way that they have been developed. It's their application in this region that we need to look at. The principle of good faith is valid. The principle of non-delegation is valid. But how does it apply here, given the explicit finding that sovereignty wasn't consensually ceded? And if we have a look at those sorts of things, then we get the unique, we understand the unique status that Te Treaty was supposed to protect for the many holes of Ngāpuhi within the exercise of overall authority within their region. And I think that's an important issue to keep in mind.
Excuse me, can I just interrupt a second while you're in full flight? So are you saying that there'll be many opportunities, obviously. So are you saying that those principles are valid for everybody else, but not for Hokianga? Is that what you're saying to us? No. What I'm saying is the principles are valid. Yes. And the principles are generic. Yes. But their application is specific. Okay, thank you. So, if, for instance, my hapu had signed the English version, like Miss Waters did, there was a particular arrangement that would have been expected coming out of it. And the application of the principle of good faith in terms of treaty interpretation prevails. You need to. But what is a little bit different there is potentially what is, if we are to take a plain text approach,
what has actually been agreed for the Crown to exercise. Over here, we've got a finding that says they never agreed to that. Therefore, a principle of the treaty can't be that, a principle of good faith can't be that you can give away what you didn't get. That necessarily has to breach the principle of good faith. So those principles of good faith, and they are a little bit further into the submission. I look at principles of respect and trust for nations as a whole. I look at the development of the principles of the treaty, and then my submission, there's a confluence. There's a confluence between what the principles on their face say, but the problem is how they get exercised. So I heard submissions being made that there's this principle of autonomy. My submission is that the principle of partnership is valid, but what that partnership should look like is a live issue. And again, we come back to the status within the relationship. Māori expected to have a relationship. You can call it partnership, because partnership can mean a number of things. But they didn't envisage that the partnership would have them lying in the ditch, impoverished, absent any opportunity, while the Crown's derived benefits off their whenua, moved away, constricted their development, pushed them off their lands, created education systems that have deprived them of their tikanga and their mātauranga. That's not the partnership that they envisaged, that Buck was talking about just before me. But they still wanted a partnership, but just an honourable one. And the key theme, well, I'm going to say the Buck said, integrity, and truth and integrity. That's what's been missing in the treaty relationship. It's the truth and the integrity. Not only have Māori been suppressed, but the Crown have lied about the treaty and created a mythology that reinterprets the relationship to suit itself, or to suit what it wants to achieve. And that in itself is an illegitimate exercise of sovereignty. When I read again I'm jumping around, when I read what Brookfield says, what becomes clear is the only people that have accepted that the Crown can assert sovereignty as a legitimate exercise of authority in Aotearoa are other countries that weren't party to Te Tiriti. Well, they're irrelevant in the determination of what a treaty principle should be. And I think that's where this tribunal needs to be careful in maintaining its focus on those on principles that arise out of the treaty, rather than legal mechanisms that have been developed around principles that are applied in a fashion to entrench the exercise of authority and sovereignty, rather than anything that goes back to the treaty. And a paragraph, I'm not actually going that fast, page 12, I refer to the framework that Professor Hohepa talks about, and he goes on to observe at paragraph 43 that through Te Treaty, Hokianga Rangatira sought to protect our ability to maintain our rangatiratanga, and the Crown promised to assist us in that endeavour. There you get those spheres working together. Yeah. And it's not, so Māori weren't saying, leave us alone, we don't want you, we don't want your help. They wanted the help. But assistance and accommodation of assistance is different to saying, come and be my God, or come and impose yourself upon me and all your systems. And if they had have done what they should have done, then they would have facilitated us in the maintenance of Te Kawa o Rahiri, as Hokianga Rangatira tried to do, working within those systems like Pi and Mohi Tāwhai, Ri Te Tai, rather than defeating them and defeating them even when they tried to work through the institutions. And that's why we want rather than arguing about what sovereignty should be or whether there are 2 spheres or 3 spheres and complicating everything, let's just look at the relationship that's envisaged by the treaty, simplify it and see where indeed the Crown promised to help Māori and how that was supposed to happen. And if the Crown was right, why has there just been consistent protests from basically as soon as they've imposed their interpretation? So I stepped through there, and I just want to go to paragraph 59 of page 16, and this is a different way of depicting it, talking about the governor and his relationship, and maybe how these spheres of influence work together. The governor was supposed to be a helmsman, not a captain of the waka, and definitely not the navigator. At a high level, this was how the spheres of influence and authority were to be upheld, and this provides a basis of how Hokianga initially sought to manage and maintain engagement on their terms, which is reflective of what Patu said about te kawarahiri. The exercise of kawanatanga by the Crown would be accommodated by the ongoing exercise of tino rangatiratanga by Hokianga rangatira within the maintenance of te kawarahiri. The corollary of the tribunal's finding that the sovereignty was not ceded is the question, how then does the Crown subsequently achieve sovereignty in a practical sense, in the sense that it exercises it now? On this point, you were silent, and this is the issue, and you quite rightly said that was the issue for the stage. And there's the quote from the tribunal there. The findings of this tribunal in its initial report have been met with relief by Hokianga, but were largely dismissed by the Crown, not surprisingly. The suggestion is that there was a departure from jurisprudence that had been developed, as in this context it is perhaps important to revisit some of those earlier tribunal findings. I note that this tribunal seems to have returned to the conservative approach of the initial tribunals who reflected on the fact that tino rangatiratanga wasn't being ceded, and I set out a passage there from the Kaituna report, the Manukau report, and just the Kaituna and the Manukau. I thought there was another one on the Mutunui Waitara report. So the initial finding resonates with the clear reading of those things. And again, if the principles are developed on that basis to maintain the integrity of the understandings that existed within, then there is nothing wrong with the principles that exist there. Now the next section I have, it's entitled Engineering a Narrative of Consent. And I've already glossed over the lies that have been told in terms of justifying the exercise of authority by the Crown. My submission is that re-engineering of history is in itself a breach. It's actually the mechanism that the Crown uses to breach the treaty in an ongoing way. So that's myth-making and lie-telling is not good faith. We've come back to the beginning. There was no consent within the treaty, so the treaty cannot be now used as a mechanism to justify subsequent proclamations that existed that basically then they turn around and say, wow, even if they didn't sign the proclamations made it clear. So was consent really necessary, or were those lords just talking about things that weren't really important? Well, they were really important to Māori, and they shaped their understanding. Well, their understanding seemed to be shaped on that necessity for consent. Now, this is where, from paragraph 83, I talk about Professor Jock Brookfield, and he talks about it as a literally revolutionary and a seizure of power, with the Crown taking more than was ceded by Te Tiriti o Waitangi, by taking more than kawanatanga from the signatories. So that's his quote. Notwithstanding the revolutionary seizure of power, Brookfield considers that the treaty has nevertheless become a constitutional standard against which the conduct of the Crown toward Māori and Māori claims to rights against the Crown are to be assessed. Well, if they are to be assessed against the treaty, they need to be assessed against the truthfulness of the treaty, not about the re-engineered reality that the Crown wants the treaty to be. Brookfield attributes the legitimisation of the original seizure of sovereignty to the passing of time and subsequent acquiescence within a dominant constitutional framework. Well, that's oppression. And the benefits that colonisation has brought. Well, the benefits of impoverishment, thank you, but that's not really reason to agree to the coercion. So it's respectfully submitted that the views of Professor Brookfield fall somewhat short of the mark and are merely another attempt to manipulate facts to impute consent where none exists. Firstly, as these submissions will highlight, the benefits of colonisation that were promised did not necessarily ensue. In fact, they were withheld and given to other people, and so that a vulnerability could be created, so a perception of consent could be inferred. It should be noted that the application of the betterment principle was utilised in the public works framework to justify denying Māori compensation for lands. So, you know, we don't have to pay you for your lands that we're going to take off you because you're going to get something good out of it. Māori continually been told, what are you moaning about? You got all this good stuff. Oh, no, we didn't. You got all our good stuff. And I think that's the nature of the narrative that needs to actually be reflected. And I'm saying it quite bluntly because it has to be. It's very clear. The lies that have been told to force Hokianga to accept the oppression and blame themselves for it, which we talked about, which Fanon talked about, what I talked about in my opening. This is how they did it. We'll take your lands from you because we're going to give you something better. And when Hokianga Māori in particular were begging for that something better to allow settlers to come and live amongst them, the Crown then went around and dissuaded settlers from living in amongst them. Said, oh, it's not a good place. It's not a good place because we can't exercise authority properly in there. So those benefits were withheld, and in terms of cutting rights around trees and blocks, they were held back so that land couldn't be sold. And that happened around in the Mangamuka or Mahuta region. Paragraph 89, I reflect on a comment that the Waitangi Tribunal made in its Te Uruwera report. And it commented on the way in which the law employs devices in such circumstances to give moral legitimacy to circumstances which are not supported by the facts. It's a rather profound quote from, that was an exceptional Waitangi Tribunal. But that tribunal was grappling with the fact, a similar fact pattern to Mangakahia, where there had been no engagement, where there had been no effort to get consent. And that's what it said, is that you can't, that sometimes the law just does it. We just create some mythology so that things look like they should happen in the way that they're going to happen, but there are no facts to support it. And that's, if we're not careful, that's what the principles can do. The misapplication of good principles can be mechanisms that oppress and destroy the aspirations of Hokianga under a show of justice. And that's that next paragraph 90, and that's the quote from which that Alan Ward piece gets its name. We need to be careful that the law, that people are not impressed and destroyed under a show of justice. That provides justice because you might get certainty, but that's not justice for the people who are being destroyed and oppressed. And I just note that while it does seem that we might be trying to retraverse issues that you dealt with in stage one, this is actually trying to take on that new chapter and contextualising that relationship moving forward to answer that question that was left hanging by this tribunal. And highlight that essential context of this tribunal in its initial report was that non-session, the non-session of the ability to enforce or make laws over Māori, or issues relating to their principles. Hokianga rangatira of the time, and I'm at paragraph 92 here, would have legitimately expected that their rights and obligations to exercise power and authority to maintain te kawa o Rahiri would not only have continued, but the ability to do so would have been enhanced and protected. So protect us in our ability. What we've got in my submission is mafioso protection, where the Crown comes and says, we're going to protect you, but we actually need protection from the Crown. So we give land to the Crown so the Crown can protect us, and the Crown is the mechanism of our demise. And that's the protection that's been imposed, and that's not the protection that was envisaged within Te Tiriti o Waitangi. So logically, it must, the imposition of sovereignty by the Crown breaches the agreement and its very terms in itself. This position, and that's, even if this tribunal finds that there's been a subsequent erosion of willpower to constitute acquiescence, that Brookfield seems to suggest that the war of attrition, the war of 1,000 cuts, or however you want to put it, that they've broken down, they've broken the backs of Hokianga rangatira to the extent that they're just saying, oh, go on and do it, then that can't be seen as being consistent with Te Tiriti. If it wasn't given in the first place, then they didn't agree to a process that would break down their resolve to hold it. So Brookfield's hypothesis in itself is inconsistent with Te Tiriti. Now, at paragraph 94, I say that this tribunal is being put to an ultimate test. The argument about the illegitimate exercise of sovereignty by the Crown represents a challenge to the tribunal that if its mandate is to explore, examine and report on violations of Te Tiriti, it needs to do so in all integrity, looking at the essence of those violations, which are fundamental constitutional violations in the exertion of Crown sovereignty. The irony that exists within this ultimate test is perhaps that the powers that Hokianga come before this tribunal to challenge forms the framework that denies their full analysis within this tribunal. We ask the tribunal to keep in mind that its significant jurisdiction relates to making findings and recommendations based on principles of the treaty. And I said a principled approach to extracting principles from the treaty. It must take care that it does not become part of the manipulation that occurs to reinterpret those treaty principles so that legal principles based upon fiction can be maintained. Or they can be maintained in a way, or they can be applied, that the principles are applied in a way that is inconsistent with the promises of Te Tiriti. The Crown in this district cannot rely on Te Tiriti as a mechanism of consent. The genesis of any legitimacy to its exercise of authority over Hokianga must be seen to lie within the exercise of brute force. This being the case, the exercise of sovereignty cannot be seen to be based upon Te Tiriti, or indeed be seen as being inconsistent with any of the principles that might emerge from it. And I set out there in detail a submission around the historic injustice that has occurred, the usual arguments that are made to maintain some consistency, to try and confine the way in which this tribunal can consider things in terms of the rule of law, and how they are juxtaposed against the rights and obligations of Hokianga. I'll stop at 12:45. Sorry, Miss Neems is trying to truncate 20 minutes out of my time. So, look, so I am on track. I do want to focus on the principles of the treaty, because I think it's important in terms of that Hokianga context. A lot of this submission relates to the way in which native land court, old land claims processes, and those sorts of things were used to remove or to impose authority by the Crown and remove and constrict the ability of Hokianga Māori to exercise rangatiratanga. So I am trying to take a bit of time on these issues, which I think is a good place for us to engage in terms of laying a tuapapa for the findings and recommendations that might come out of this this process.
The comment was made the other day with regards to the principles, and sorry, I can't recall who it was, but we actually asked the question of them, one of the council, saying that rather than looking to other tribunal reports to establish what the principles are, there is a need in these circumstances to look at these Ngāpuhi circumstances. And that's what stage 1 did.
Yes.
And therefore, the principles that we should be looking to derive from those circumstances, not from someone else's circumstances. Do you have a view on that?
And my view is...
I mean, and also given that we are a tribunal and we must, I mean, there's precedent that we must follow in terms of the Court of Appeal and other courts. But what's your view on...
Well, I did make a submission, sir, in stage 1, and I haven't got it on me around the fact that as a Commission of Inquiry you're not necessarily bound by the Court of Appeal, and that you have the exclusive jurisdiction in the determination of what the principles are in this context.
I didn't say we're bound by them, and we said that in stage 1.
Yes, I think so.
But there are references that we can look to. But the point is, do the principles for this inquiry derive from the circumstances of this inquiry?
And my view is yes, but then when I look at the principles that have been derived in other inquiries, when you stand back, they are largely the same. Good faith, for instance. But what does good faith mean in this context? And that's why I'm saying the principles are the principles.
Because
their
there's
application
a whole body of jurisprudence to draw on.
Yes, sir. And I go through this. I apologise for filing this late, sir, because you would have been able to go through this. But
well, at about 3 o'clock this morning when I finished it, I didn't get a chance to go through it.
That's all right, sir. I was still trying to print the hikutu at that time. So, but if we go from page 22, I talk about principles that are inherent in nationhood for Hokianga. And when you look at them, there's the right to be distinct peoples, the right to their territorial integrity, the right to freely determine their destinies, the right to self-government, the right to have previous injustice remedied. Those aren't treaty principles, those are principles of nationhood. When we look at the treaty principles that have been developed by this tribunal, active protection. But see the active protection, my submission is a good principle, but the active protection of what? It's not about the Crown actively protecting Māori taonga, it's about the Crown facilitating the Māori and their ability to actively protect their own taonga in terms of a status. So rather than coming to Haki Romana and saying, tell me where your wahi tapu is and I'll protect it for you. It's actually facilitating Māori in their ability to go onto those lands and say, hey, stay out of our urupa. Stop taking our bones, and have them and force those those people that were supposed to come under that sphere of influence, actually making it have some effect. To a certain extent, that still plays out. And when the generic submissions were being given, I was talking to you about the Rahui case that was coming up before Justice Whata, as it was 2 weeks ago. So that's still before the court, sir. But that's about Māori looking at the imposition of Rahui in a way that's enforceable. If Māori go and put a Rahui, and you would have heard John Clarisic talking about this at the first site visit before the Pangaru hearings. He talked about the Rahui that was placed over the Hokianga Harbour, and he thanked Sir Ranginui Walker because when everybody when all the racists and rednecks were coming out and saying Hokianga shouldn't be stopping people going on the water, it was only Sir Ranginui that wrote a paper that said, what, they only did 4 days, I would have done 4 weeks or 4 months. But the very real issue was that mechanism of control that was imposed by Māori was unenforceable. The Crown did nothing to facilitate Māori in the exercise of that mechanism. And what that does is it renders that mechanism irrelevant. The way in which the Waimamaku caves were desecrated and all the taonga taken out of them and shipped down to Auckland shows that the ability of Māori to maintain their taonga that should have been protected wasn't. And all efforts of the Crown to say, I'll hold it for you, I'll look after it for you because you're not good enough to look after it, basically mean that those taonga were taken off Māori. And now, we are, as you would have seen in the evidence, we're fighting over how it's going to come back and what's going to happen when it comes back. And everybody knows that we have to have a discussion about it. But then in terms of blaming ourselves for the oppression, we're sort of sitting there saying, well, do we have somewhere for it if it comes back? Because our lack of capacity and all those sorts of things that happen. Those are the very, very real ripples down the generations of an issue that occurred back in the early 1900s, which was essentially the rape and pillage of our taonga. They were wakatu papaku that were carved by Kohuru, the ancestor of Ngai Tū Te Auru. Doesn't get much more significant than that. So I think in terms of, so we look at active protection, but active protection of what? We look at good government. Good government is the exercise of government in a way that should facilitate the exercise of tino rangatiratanga. Not provide mechanisms to make sure that we're not trampling on it too much, which we do. If you have a look at the way in which take into account the principles of the Treaty of Waitangi are put into legislation, there is a feta. There never is an empowering thing, there is a feta to what the Crown actually wants to do. And that's the way the Crown continues to see the Treaty of Waitangi, as a feta on its exercise of authority, when it should be the mechanism that empowers the relationship. And that's the consistent twist. And as that happens, Māori are painted into, are called protesters and radicals because they want to hold on to their taonga. They're told that that's unreasonable, that's repugnant to what Pākehās would want to have, and they're marginalised in their efforts to exercise rangatiratanga. The local authorities should, the exercise of local authority, if it is to be exercised in any way, should be to uplift Ngāti Hau and Ngāti Kaharau so that they can determine what happens to their river, so that you don't walk into the wharenui or the wharekai and see the line that's about my hip weight, my hip. That's how high the water goes up in there. Now this marae's been there for generations. It's only started flooding since they reclaimed all the land and gave it to the Pākehās. So Ngāti Hau and Ngāti Kaharau have paid for others to benefit. And Brookfield says that Ngāti Kaharau and Ngāti Hau should be thankful that their marae is flooded so Pākehās can have land. And I think that's a very, very clear issue, because public works takings that have affected Māori in this region, then when a public works exercise was making land available, where was the comeback? Surely if you're taking the lands off the Māoris, you've got to give them some. But that didn't happen. Now, from paragraph 118, that's where I talk about, I think there's a confluence of approach. So I think we could step back and develop a whole lot of new principles, but I think we'd still end up with the same things: good faith, the need to facilitate the exercise of tino rangatiratanga, and the need to only delegate. You can delegate without breaching the treaty, but as you apply that in this region, you can't delegate what wasn't yours to delegate. So in terms of, perhaps even Section 33 of the Resource Management Act, the delegation of authority from local authorities, the assumption inherent within that section is that local authorities are the sovereign within the district, and that where Ngāti Hau, Ngāti Kaharau, Te Māhure, Ngāti Pākau, where they can prove to the Crown, prove to the local authority that they are worthy, then maybe they might be able to have some exercise of delegated function. Now that, in my submission, is the flip side of what should occur. Yes, I think there should be localised authority, I think it, but that should be done by the hapu, by the holes, by the whānau, however you want to put it. And if there is any delegation, that's where the delegation should be made from. So, I've gone through a lot of contextualising the illegitimate imposition of sovereignty. And again, just want to be really, really clear. We actually, realistic, we can see that authority is being exercised over us. Just don't accept that that's a legitimate exercise of sovereignty that was contemplated by Te Tiriti o Waitangi. And the pages that follow, it's perhaps in terms of contextualising the imposition, at paragraph 151, I note the way that impoverishment was used, the impoverishment of the whānau and hapu used to achieve that, by separating of Hokianga from their whenua, which should not be seen within separate notions of social economic indicia, the impoverishment intact and eroded at their very identity and ability to be. And there, Claire Morgan, she says, for us as te māhuriri, like many other hapu, the land is a living being with a life essence, an identity, a living whakapapa. The whenua unites us, our whānau and our hapu, to the past, the present and the future. Every member of our hapu has the connection with the land, which ultimately derives from the traditional history of the origins of mankind. Now within that quote, sir, you asked Mr. Tupara about maunga taniwha, and is it yours by ownership or connection? Well, it's kind of like when your father gets put in jail, he's still your father. And you still have those obligations. And I think the imagery that Claire puts around that is quite clear around that sort of thing. Now we note the imposition.
I like my imagery better than the father in jail one.
Well, it's our aspiration that's been in prison, sir, so. But yours might be better looking. Now, I talk about the imposition of authority through war. And I think it is important to note that the role that Hokianga, some of Hokianga, played in that war. But I did contextualise it with, within here, cross-examination of Ralph Johnson. He confirmed that Wakanene, like Honeheke, was seeking to keep the Crown out, keep the troops out in particular, and about poking the bear and not allowing them to come in. So it's actually important to note that, notwithstanding the fact that even if you draw the inference that Hokianga were sort of fighting on the side of the Crown, the economic blockades and things were still put over Hokianga, so they were still punished nonetheless within an exercise of brute force that was essentially based on the Crown's ability to stop Hokianga from exercising its rights of development. And I guess paragraph 160 is instructive because the 1845 naval blockade did not include the Hokianga harbour, but the blockade on the eastern seaboard still had economic effects. These effects were acknowledged by the Crown, and at least insofar as they impacted upon Pākehā in Hokianga. When it was agreed not to punish a Hokianga settler who avoided custom duties on goods he imported, he was let off due to the hardships caused by the blockade. When it came to the great privation and misery imposed on Hokianga Māori by the war, however, officials simply observed it was an unavoidable accompaniment of the war. It was a war that Hokianga rangatira had done everything they could to avoid, and my submission is that it was foisted upon them, and they were punished nonetheless. Again, I go through some further mechanisms, again around old land claims, the imposition of scrips, the removal of land, the removal of the ability to develop, and the constriction on trade that was imposed upon Hokianga. And again, that's about constrictions and creating impoverishment and vulnerability which the Crown used to further its reach of authority. At Kohimarama, and I'm at page 52 now, there was a reaffirmation of Te Tiriti. And again, as I said the other day, it's important not to take particular speeches in isolation. If we were to go through the speeches at the signing of Te Treaty, they all opposed it, maybe except Wakanene and those sorts of things. Similar sorts of things at Kohimarama, particular things were discussed. Ms. Wara makes the point, they might have been mistranslated, and we don't really get the understanding, but what we do get is the agreements that were formed afterwards. The creation of runanga through which Māori would be able to exercise authority over their lands in a real way. And at paragraph 241, I note what they sought to establish was a form of political and economic partnership with Crown and settlers, something they had envisaged that the Crown had yet to deliver on. And essentially, those arrangements, the efforts of Māori to set up their own structures, their own runanga and those sorts of things were curtailed by the Crown because they saw it as a challenge to their authority. And so they were constricted. A number of reasons are given around the ability to fund them and those sorts of things, but really they were just constricted. And I note that at paragraph 252 that the disestablishment of those runanga were political decisions. And that's actually talking about the new institutions that replaced, because it wasn't good enough for Māori to have runanga that came from themselves. Māori forms of expression around this time, they're having to be sanctioned by the creation of an act. So, look, I've heard a lot of people ask for, in their remedies, mechanisms that would empower hapu and provide for hapu. But that's the same thing as these old runangas where you need a Crown Act to create legitimacy for the hapu and their exercise of authority, which I actually think is a breach of the treaty in itself. And what it is the exercise of authority doesn't need to create the authority for them, but it needs to actually show that any exercise of authority needs to be done in a way that facilitates Māori in their ongoing exercise. And in my view, as this happens and the capacity of Māori grows, as we have found in the Bay of Plenty, Māori stop becoming mere opposers within consent processes, and they start working willingly alongside developers in a way that empowers the region, not necessarily with the councils, but with the actual developers themselves, and an exercise that probably should be reflected within those local body establishments. And I guess probably what adds to it in the Bay of Plenty is they actually have Māori councillors that are put on that council. They're forced to have them, so there's a bit more say in terms of who the commissioners are and what happens around those sorts of things.
Just being aware of the time, Mr. Poe,
Yes,
I did want to hear what you had to say about the principles of redress and the remedies, because your closings on this are probably more extensive than anyone else has put in, and you've put in the approach to relief, the restorative approach, etc. Because in terms of the principles of redress, what's the point you're trying to make there?
Which page are we on, Sue?
126.
126. So,
it was something that Ms. Neems said that she'd defer to you on this issue.
So,
what's the approach you want this tribunal to take in terms of redress?
Okay, then
Is that what you're going on about there?
Yes, sir, I am. Just because I guess that will be a good place. I'll wind up on that section. I just.
Well, you want to take us through something else before we get?
Yeah, just one of the things, and it's not a change in the submission that's there. I just want to add something there, and as I went through the evidence that's been adduced, that's been spoken about within this week for Hokianga, I noted that there were, like Ms. Wara, that there were a few briefs of evidence that haven't actually made it to.
Well, Ms. Wara had all this in her closings, but she didn't actually address it.
No, sir. And I do intend to address it, but just in terms of, there was some significant evidence that was put before this tribunal for Te Popoto at the Mātai Taua. And we've talked about education at page 119, and I've in particular mentioned Ipu Whakatara Absalom and Arapera Ngaha. And I just want to put a hook in there for the evidence of Rangitehau Hills, Ruth Hills, who actually, again, was an educator. She must have been a good teacher because she was my teacher when I was an intermediate. Her evidence isn't referred to, but that evidence, and it supports what's in here, is that V14. So just as the tribunal goes through there. And there were, in particular, there was Ramari Kingi gave a case study within the Utukura region of Crown purchasing, and in terms of that deprivation of whenua, she noted that 7,869 acres were alienated within 2 years, leaving 66 acres, which included an urupa. And I just would like to, you know, as these, when you're considering the lot of Hokianga, in particular that evidence of Rangitehau Hills, because she suggests mechanisms that can help achieve cultural responsiveness within education, and I commend the tribunal to consider her evidence alongside these closing submissions. And so we go into this principle of redress. Now, I got that. In my view, my submission, the principle of redress sits alongside the principle to have previous injustice remedied. Now at page 27, I noted that as a principle of nationhood. The treaty principle is to remedy past breaches. It is within that context that I address the principle of redress. And I set out the theme of redress that has been developed, and the Waiheke, and there was another report. I can't remember it off the top of my head, so I don't seem to have mentioned it in there. Maybe the Waiheke report refers to it. They talk about 3 ways of providing redress: compensation, restorative mechanisms, constitutional. But in terms of how can you provide redress? How can you remedy these past injustices? In terms of that principle of redress, how do you fix it? In my submission, we should be looking at a restorative approach, and that's because these submissions go to the status that Hokianga should have in this nation, in their nation. And at page 128, a restorative approach to remedies is appropriate. This should include facilitating the restoration to an extent reasonably possible of rangatiratanga and hence the mana of tangata whenua. While the Crown cannot restore rangatiratanga in the abstract, resources can be restored to the hapu that enable it to exercise rangatiratanga. I'm going to suggest to go a little bit further. It's not just about the return of land, but it's the removal of the wheta on Māori to exercise rangatiratanga over those lands in terms of the whetas that are created within mechanisms such as the Resource Management Act. And in terms of those whetas within this submission, I set out, I won't go to it, sir. There's a series of cases that talk about the way in which the Resource Management Act propertises resources. And in my submission, that's still happening, and a restorative approach needs to halt that, because each consent that's granted creates property. Even though Section 122 of the Resource Management Act says it doesn't create property, the courts say, no, it creates a property. It's a licensing regime. That's for water. And if it is for water, then it is for any other consent.
Do you just want to step back one part, because
yes,
in terms of your approach to relief And there you're talking about full compensation. And I think you agree that there's been, was it 2 tribunal reports which say that full compensation is not needed. Well, full compensation is well, the tribunals offered support for that ideal. Is that right?
Yes, sir. And so, look, in terms of what's lost, and ka riro whenua atu, ka hoki whenua mai, those full compensation are based on those sorts of things. But full compensation only goes so far. If it doesn't provide, if it's provided in a way that it can't be used as a mechanism to facilitate the restoration of the status of hokianga and the exercise of tino rangatiratanga, then it provides an ineffective tool. In a sense, it's giving a man a fish instead of giving him the tools by which to feed the generations that follow. I think this is how I think we should look at Māori hokianga deserve to be compensated, but they deserve to be, that compensation can't actually exist within a rigid framework that denies their ability to utilise that compensation within a way that sees them exercising mana over their rohe in a real sense. So, for instance, if they got the billions that they lost back, but they were still stuck within a resource management framework that prioritised the resource rights of others to their detriment, then that full compensation will slowly be eaten up within grinding Crown processes. And it will look like the way in which the Crown have provisioned or under-provisioned entities in the past, like the Māori War Effort Organisation, those sorts of things, to create dependencies, because it then gets used in that sort of way.
And in that way, I suppose it's consistent with a number of the closings where the main theme has been about tino rangatiratanga.
Yes.
Money is not going to buy you back tino rangatiratanga.
No.
It's the restorative approach which you'd say would, well, not be the priority, but there should be some focus to that.
I think, well, my clients, they're realistic in that if settlement is achieved, that's not where their tino rangatiratanga is going to come back. Their tino rangatiratanga will be rebuilt by themselves.
Control and
control, but
autonomy.
In terms, well, see, 5 years ago I would have said autonomy, but the reading of Te Treaty in this region is about not necessarily autonomy, but working together and being helped and facilitated. And that issue of partnership becomes a very, very real one. The reason that Māori sought autonomy, and you see it in Mohi Tāwhai, was because his efforts within the structures were absolutely thrown out. That's why he called for the abolishment of the House of Representatives. And then when they wouldn't listen to him, he started working in the Te Kotahitanga movement. So the development of these autonomous organisations are a reflection of or a response to the ongoing Crown's denial of them to exercise rangatiratanga or facilitate its exercise. So I mean, if you asked anybody from Ngāti Hau, Ngāti Karo, do you want to be the local authority in your region? The answer would be yes. How do you do that? You actually remove the current local authority. It's not about you giving them the mana, it's about removing the constriction that exists there. To a certain extent, some have tried to do that through might, and you see that happening within the Tainui region. And you see a vision statement that now sits above any national policy statement, that where a regional council has a regional plan that's inconsistent with that vision statement, it has to be amended to reflect the vision of Waikato Tainui. So you see them actually building and stripping back and asserting themselves in a dominance within their rohe. My submission is, while Te Treaty envisages a working together, it still envisages a Hokianga dominance within Hokianga.
So co-management agreements aren't your thing?
See, co-management is like partnership. Partnership can mean a whole lot of things. Partnership can be a good partnership where I am the managing partner in a thing. But where co-management results in the CMS being written by somebody else and it gets implemented in a way that is, and Te Māhurehure get to co-manage the way in which the river flow is monitored, well, that's not an exercise of kaitiakitanga. That actually just enhances your position on the sidelines of your demise.
What about in, I think that quote there at page 128, under the restorative approach, the restorative approach to remedies is appropriate. This should include facilitating the restoration,
yes,
to an extent reasonably possible. How would you frame that in these circumstances?
See,
because that's the catch, isn't it?
That
well,
is
the catch from this
and that's why I say the process necessarily needs to be an ongoing one. It isn't one where you can just say, okay, because I mean, if you turn around and you went,
I mean, and I'm talking from us making recommendations. You know, they've got to be of
and I'm trying look
use.
In terms of, for instance, if you said, if to an extent that's reasonably possible, needs to understand where the tangata whenua are heading, but also needs to be reflective of some current realities. And I only use an example. It's another Bay of Plenty example. It's Motiti, where they didn't have a plan. Every consent was just rife, and things happened. The island developed in a way that wasn't good either. So you can't create anarchy, because if you do it too fast, it'll destroy the aspiration that's being sought to be achieved. And this is where I like what Moana Jackson, he says, look, it'll happen. It won't happen overnight, but it'll happen. And I think that's what a restorative approach should be. It's not about giving the fish, it's about giving the tools to fish. Now,
and what Waikato Tainui have achieved with the river, again, took a long time to come out the other end.
Not only took a long time, it's what, the second settlement? Yeah. So these are people that have become actually, and they have the capacity to exercise those sorts of things. A vision statement for Ngāpuhi at the moment, where we can't afford to participate in a resource management approach, so we're bound to a resource management approach, but we don't have the ability to participate in those lengthy regimes that were described in particular around whatatiri, achieves you nothing.
The recognition within the broader community of your status as a result of that first settlement is crucial in going on.
That's right.
To the next stage, because there would have been many in the 90s in terms of local bodies that wouldn't have considered the possibility of sharing or even making their own authority within that of Waikato in relation to the river.
The string of opposition to the consents that were applied for the base outside of Hamilton shows the way that people within Hamilton sought to diminish the ability of Tainui to achieve their aspiration. You only need to go through those oppositions and how they were actually around diminishing the development potential that was going to be sucked out of where they were exploiting it. Now with the tools, they can actually exercise those things.
So could we just go back a step to the Bay of Plenty, where you talked about a Māori representation on the council, and having the power also to choose commissioners and so on. Is that part of the process that you want to see emerging, of a slower process, or do you want to? You don't want that kind of...
No, I think that could be a mechanism to take us beyond where we are as a stepping stone to where we want to be. And it needs to... when you hear people around Ngāpuhi talking about settlement, you know, there's this need to address particular problems that sit within here, but we can't lose sight of the aspiration that everybody's talked about within these hearings about the achievement over time of our tino rangatiratanga for ourselves to exercise within our rohe. And I guess having 3 people on a bigger board is better than what we've got now, but that's not the aspiration that's been voiced within this.
That's not the ideal. At page 131,
yes.
I just wanted to get clarification here, and it's at C. And it's, the question will be whether the tribunal should seek to apportion or declare respective interest at all, or should simply declare that both successful claimant groups have an overall interest, leaving it to them. So what are you asking for there? What's the approach that the tribunal you think should take?
I think my submission, there's enough evidence before this tribunal to say
this is when there's a number of claimants who we say their claims are well founded, and then
look, and I'll colour my response with the reality that there aren't resumable properties within Hokianga. So the need for you to particularise the particular properties that we might seek to exercise resumption over isn't the same as other people who have got a forest in their region. Because a resumable property, we've got Mangatoa, which is a resumable property. It's a farming station. But the benefits of a resumption application lie in the rentals or the compensation that this tribunal can order up to 90%, which might relate to stumpage, and in those recommendations, the potentials have dwarfed some of the settlements that have been achieved by some of the groups. So, in terms of what Hokianga need in terms of achieving an outcome and using this process as a stepping stone, is to note that the hapu that have come before you, even the ones like Ngāti Toro that didn't have a claim that were helped, those hapu have still been prejudiced by Crown actions, and that's clear. They've been prejudiced as whānau, they've been prejudiced as hapu. As the Hokianga Collective, which spans into and outside of Ngāpuhi, they have been prejudiced and they have valid claims. And that these claims need to be redressed and remedied. And that the vulnerability that exists within there cannot be preyed upon, as Dallas King says, to attract funding to a region so that it can go out to the rich places in the other areas. They're still preying on our vulnerability, and they're still blaming us for what we've done. Now, within this redress here, and this is one of the things I do want to touch on in terms of, because it is part of a process.
Want to touch on that and then?
Yeah. So I think you understand the approach to redress that I'm putting in there. One of the mechanisms I've put in is I have noted the way in which this process has enhanced the ability of hapu to engage with each other. Not before the tribunal, but in the way that they've met monthly. They've come together, they've discussed their ngawe, they've discussed settlement opportunities. We've been able to fight with each other. Oniro's been able to go back from a meeting and tell the radio that Jason doesn't know the difference between a hapu and a iwi. All these sorts of things have been able to come out. Now, there's been a particular momentum that's been achieved and a particular cohesiveness that was reflected upon in a memorandum that you gave at the conclusion of the stage 1 hearings, where you reflected on the way in which hapu had come together to present before this tribunal in the true spirit of ko whaoro. I would be seeking interim relief that the Crown facilitate those ongoing meetings. Those were the meetings that were envisaged at Kohimarama and Barawhakaputanga, so that the hapu can be facilitated in their objective to maintain their cohesiveness, so that these claims that they have fought through their blood, sweat and tears, through which we've lost Tupari Tito, Mata Naira and Auntie Celia Birch, that those people that have passed, that momentum can be maintained, that it doesn't stagnate and is allowed to be captured by another group that might swoop in for a mandate to try and negotiate particular things. And I see this as a particular issue for this. There has been significant cohesion, and this is one thing in terms of this tribunal and the healing process that it provides. It's allowed people to be identified who can actually do the work, who have the stamina to still be there, those sorts of things. And in my submission, a recommendation emanating just after the Crown replies to say that that's something that should be facilitated would be a way of facilitating Ngāpuhi maintain the mechanisms to maintain their own tino rangatiratanga, to maintain their own views and their own fora. Because I worry that when this process finishes and this isn't happening, that the stopping of the meetings and that there will be there will be a reverse in the inertia that's been obtained helpfully through the discussion and the airing of issues and grievances before this tribunal. That would be the last thing that I possibly needed to say.
Tēnā koe. Thank you, Mr. Pope.
But if there's time in the next hearing, I'll finish the rest. Hey? Oh, you want?
I roto i te whare tapu o Ngāpuhi. Ko hokianga te wāhi o Wanganui. Kei reiro hoki te paia kautariri, te kawa o Rahi. So I was asked to talk about the kawa o Rahiri for a while, because this has come out in all the explanations. Our unity is based on that kawa, which, to put it simply, is divided interlocking protection. Hapu and hapu clustering are our principal units. Within are whenua, whānau, tikanga, mana, tapu, rangatiratanga. There's a book needed in time, and I'm hoping that someone here will start thinking about writing about that. I want to turn to another matter. That whare tapu is within a larger whare. E whā ngā pātu o taku whare, te au pauri, Ngāti Kahu, te Rarawa, Ngāti Whātua. Ko Ngāpuhi te paparahi. Ngāpuhi is the supporting foundation of that house. And that is why our hearings group is not a waka, not an iwi, not even Ngāpuhi. It is the paparahi o te raki, the foundation of Tai Tokerau. When we understand that, we then understand where we are going and what is the thing. And I thank Jason for putting together everything which to me was so disparate. But where is this leading us? From the grouping I just mentioned from Ngāti Whātua northwards, it's even in Auckland coming north. We, the indigenous peoples, are suffering. We are a third world country, illegally occupied. That occupation came, as explained, starting through the wars in the north and continued. Our tikanga, our tino rangatiratanga was removed by a group we had allowed to settle in our country, to form their own government. And this is, of course, what you wrote about in the initial hearings. anywhere else in the world, that kind of takeover is treason. And that you have heard. So we start looking at what are the solutions we have to look at. Poverty has hit. South Africa has removed apartheid, and yet it seems to have continued to keep the idea of Hokianga and other areas being Bantustans. Bantustans to supply other countries, mainly Australia. But then I have a Mokopuna who is working across in Malaya as an engineer, plus others who are in other parts of the world, and yet our areas left behind are vacant except for us, Kaumatua, and a whole lot of children and mothers, and that is part of the effect of the Crown on us of the Taitokerau, right through to Hokianga, right through to Waima, Omanaya, Whirinaki, and all the people who are here. So what is the solution? Immediately, there should be the beginning of the removal of that poverty, the assistance to communities, the assistance to those of our communities who are in motor cars as their homes in the streets of Auckland. And when you do that, and we get the equality that was promised by the treaty and He Whakaputanga, that you will not be way up in the hills, high up above us, and we are the little mountains below, said one of our ancestors who signed the treaty. When we can get that kind of equality right across Taitokerau, and then the second solution is the honoring, the legalizing both nationally and internationally of He Whakaputanga and the Treaty of Waitangi. Then the third is, once you've got us to an equal level and got that, then it is time to think of settlement for the damage you had done for the 173 years since the time of the signing of He Whakaputanga. Now, in that way, there will be the equality that will get to the point where we achieve what the treaty in He Whakaputanga. Now, I won't go any further than that because that is part of the wish we have from Hokianga. Nā rungai tēnei, tēnā koutou katoa.
Kia
ora. Ko te treaty, o Waitangi, te treaty o Aotearoa, hiki te ki ronga, mo tu kāke ranga, tēnā kamatuku I o. Ko te treaty, o Waitangi, kia kaha, kia mau.
Tēnā koutou, tēnā rā tātou katoa.
Kia ora koutou. Just Kia ora tātou. I just want to make some closing remarks just before we start the Paraoa, and these will be very brief. I wanted to thank lawyers. Thank you, Mr. Hockley, for your work on the timetable. I thank the Crown. Tell Anaru he got away by going home early because Honero was after him. But most of all, I want to thank the claimants. Kia ora tātou. And I want to thank the claimants who have now provided the closings to their claims. The hearing process, if we count stage 1, started in May 2010. It has been a long journey. There have been a number of hui, and I won't go through all of them, but we have, for many of you, and your claims, some of the claims were pre-2010. For many of you, this is the beginning of the next step. You've closed your claims. There's still replies to be done and to hear the Crown replies. But for whāngarei, for mahurangi, for maunga kāhia, and for hokianga, this is an end, but a new beginning. So ka nui ngā mihi ki a koutou. Koutou I taitai mai ki enei hui, ia hui, ia hui, ia hui. Mai te timatanga o tā mātou noho ngā kai wainganui I a koutou, I ēnā tau e whitu kua pahure rā, taino ki tēnei wā. Nō reira tēnā koutou, a tēnā koutou. And we will do a post-hearing direction, and that'll have all the technical things. But at this time, I'll hand it over to our kaumātua, nāna, o māna ngā mihi ki a koutoura.
Tā te kia ora tātou. Tākina rā te kawa ko te kawa nui, ko te kawa roa, ko te kawa whakatika I ahu mai, I Māui tiki tiki a tāra. Tipu ake ai ko te pū, ko te rito, ko te weu, ko te take, ko te pūkenga, ko te wānanga, ko te tau, ko te tau. Tēnei rā te awhi nuku, te awhi rangi, te ororo I o matuakua. Tipu ake ai I ewe nuku, I ewe rangi. Tēnei ka hohau ki runga ki te tipua, ki runga ki te tawhito. Ki runga ki te kāhui o ngā ariki, e putai tātou ki te whai ao ki te amara. Ko tai rā ki te wāhanga e kapi ai tō tātou hui ki tēnei wi. Ko huri ai te aroaro o te rōpū whakamana I te tiriti ki te wākai. Tēnei rā, ka mihi ake rā kia koutou e kōrero hi ake nei e te kai whakawā. Ka mihi ake rā kia koutou I tai mai ki raro e te tūnui o te tupuna whare e tūnei. Ki te puta mai ngā kōrero, e kōrero hi ake nei e koutou kia mātau. E kōrero hi ake nei te kai whakawā, o tēnei te mutunga, o tēnei wāhanga ki roto I a koutou. Ko reira ka tēnei rā ka mihi ake rā, ka mihi ake, ki ngā pari kārangarangatanga, ngā hapū I tātū mai te tīmatatanga o tēnei hoi hoinga taino ki tono oti. Me te mihi ake anō ki te tupuna whare e tūnei. Ngā whakakai whakarite o tātou kai karakia. E te rangatira tēnā koe. Tēnā koe e arahi hia nei tātou. Ka mai te rā tīmatanga taino ki tēnei wā. I runga I ngā karakia. Ngā karakia I whakapāhohia ai e koe ki wainga nui a mātou. Kia tika ai te haere o ngā huatanga o tēnei hoihoinga. Mai tērā wā tainoa ki tēnei wā. Ko mutu rā te āhuatanga o tō tātou hoihoinga, tō tātou whakamine. Nō reira e rongo ake ana ki ngā kōrero a tō tātou kroua a te patu hohepa. Ka te raki, ko koutou rā tēnei, te whare tapu o ngapui. Ka mihi rā kia koutou. Ka tuohu rā mātou, I mua ia koutou. I roto i te hohonutanga o ngā kōrero I puta mai a koutou. Ka mihi ake rā, ka mihi, ka mihi. Ka mihi ki a koutou, ka whai kai whakarite I ngā huatanga e pāna ki o koutou kre. Ko koutou rā tēnei e arahihia nei ngā kre me ki roto ki runga ki a mata. Tēnei ka mihi ake, kia koutou te krau. Ko koutou rā tēnei te hori. Ko iono ka mihi ake rā. Ka mihi ake I runga te rangi Maria. I runga I ngā huatanga e pāna kia koutou, kia tātou, kia mata. Nō reira e rauranga tira mā, e kore tō I roa te kore. Engari ka mihi ake rā kia tō koutou katoa, ko tai mai, ko tatu mai I tēnei rā. Nō reira tēnā koutou, ka huri anō te whakaaro ki o tātou tingi aitua, ko rātau I wainganui a tātou mai te tīmatatanga o tēnei huihuinga, te whare tapu o ngāpui. Ko mene atu rā ki te pō, ko ngaro atu tirohanga kanoi. E kōrero hi ake nei rātau I wainganui o tātou kore. Nō reira hapiti hono tātai hono. Ko rātau ko huri atu ki te au wairua, rātau kia rātau, hapiti hono tātai hono, tātau rā tēnei te Marae, te hunga ora, e mihi nei I runga I tēnei tupuna whare, I roto I tēnei tupuna whare o tātau. Tātau kia tātau, tēnā koutou, tēnā koutou, tēnā tātau katoa.
Ko te aroa anō he wai, e pupu ake ana, e awa he mapuna mai ana, I roto I te whatu manawa, o tona matapuna he hohonu, aina ia ka rere anō. O tona matapuna he hohonu, aina ia ka rere anō. E tai timu, e tai pari, e tai roa, e tai oa, e tai nui. E tai nui. E tai nui.
Tēnā koutou, nā kia ora tātou katoa. Nā koe pūrina. Tēnei ka tuake. Mātakitaki aka na ki ngā whakahua nei, ki ngā kaumātu e mōhi au. Mai tērei kokonga ki a Len Man, ka Lou Davis, ke he pōhara wira, ke a ngaro pō, ke mohi tito, ki taku whanau ngā roto whakatohea, kaumātua ke a hare, whakaro akeu, he harani wā lātou whakaro mō tātou, he hatoranga mō tātou. Ko tahi te whakaro I putake I roto I au, I rungo au I te nui ngō rātou e putana tērā kore o te wehi ki a ihoa te timatanga o te whakaro nui. Hara wēnei, kaumātua katoa I mōheo ki tau, I rungo I a rātou e koro ana. Kia koia tēnā tā rātou tiroha. Hea te oranga mō tātou. Ara, I waitangi ai tērā waiata. He rongo pai te oranga, he hari mō te ao. Nā, ka tiroa ke kia koe, he one roa. Mihi e tōna kia koe. Mihi e tōna kia koe. Rawi mō heo he hatataka I hurei I noho mai te anaru. Hoino, rau kei konei. Nō reire mihi e tōna kia koe. Kore whakaloa ngea wenei mihi hoino tēnei mihi tōna na kia koe. Taipari, e koutou. E pupuri nei te mauri tēnei o tātou marae. Tēnei ka mihi ake. Ki ngā iwi o te ringa wera. Tūtau tuku ana te mihi ngā mihi kua puta kia koutou. Nōre kore whakaloa ngea wenei mihi, wenei kōrero. Haino mihi ana kia tātou katoa ngā kārangarangatanga, ngā hapu. Tai mai tautuko ni ngā mihi, ngā kōrero ngā nei e te matu e kihi. Nō reira, me wai hoa ke wāku kōrero ki konei tēnei wā. Reira huri no tō tātou whare. Tēnā koutou, tēnā no tātou katoa. Ana I taku waeta, kutaka I te matua keke me taku tupuna mahiku ai. Te matua keke a mea I nongau tēnei waeta ngana he ari nāku I huri. Penei ngā kupu. O mātou tēnei, ko te krauna. E haere nei, I te ara, I haere ai, e te hunga. Kuariro, I te pō, ua mutu, tā mātou tāhai. I ngā whenua, o ngā puhi, I tāhai ai, e te hunga. Kuariro, I te pō.
Kei wanganui tēnei whare, I roto I o koutou takiwā o koutou manākitanga kamihi atu. E torongare, tonu mai te pautoko mana o te whare nei. Huri noa kia kāka porowini, ngā tini me ngā mano, I whakairo tia mai I runga I enei poupou, kamihi atu. Me koutou mā, me tātou mā ngā tīpuna, e hui, wairua mai I tēnei rangi whakahira nei o tātou. Ka mihi atu. Ka huri ngā maharatanga kia hōri, kia tūpari mā, kua mene atu ki te pō, e rangi kei konei tonu. E mene mai ana no tua o te arai. No reira tēnā koutou. Tēnā koutou. A mā tātou te kānohi ora ngā mahi kia mahia, kia kawea, e bak. Ka tūohu, tūlau atu, kia koe. me te whakamaramatanga o tēnei mea te mana o ngai ngā hapu ki ngai te karauna. Tua kana teina pea, hoi anō, te hononga nei i raro i te maro o te tiriti. I raro i tēnā ka mihi atu. Ka mihi atu. Tēnei tino pātai i tūkuna mai e te jati. He ahanga āhuatanga e whakahaere ana i te tuhituinga o te puka nei kei te tuhi ai e te tribunal nei. He ahanga huarahi kei a rātou, a te pātai nui anō, he ahanga huarahi a kei a tātou. Kei a koutou e ngā kaitiaki o ngā pui, o ngā hapu ngā pui. Hanga anō ngā huarahi, hanga anō ngā waka, haere tonu ngā mahi. I tēnei poropora ki e mihi atu anō ki tētahi tino rangatira o mātou hunga, o te hunga ruia i mate i tēnā marama ko John, te māni hera Chadwick. Anei a ki ai e mātou hunga ko Chad. Ko ia te tumuaki tuatahi o mātou hunga. Ko ia me e tai atu ko Annette, ko Wana Jackson, ko Judge Steve Clark mā i hanga te whakaro mo tēnei mea te hunga roia Māori. Hei tautoko i ngā roia, hei tautoko i a koutou. Ngā whānau, ngā hapu, ngā whakaminenga. Nō reira, moe mai rā, taku tuakana i te rangatira moe mai rā. Hori anō taku whakaro ki te tuahine nei, he tumuaki wahine o mātou hunga, ko Jolene Patuawa. I mate atu ia, e whitu tau i muri. Kua whakatakoto, whakahoki atu ia ki taita, ki tōna urupa i tēnā atu tā o te kaipa. Nō reira moe mai te tuahine. Hakua i moe atu koe, tō tinana, anei mātou e kau e tonu ana ngā whakaro. Ki ngā tini me ngā mano e moe mai rā. Kia tātou mā, tū mai, tū tonu mai, pupuri mai o koutou kaha, kia haere tonu ngā wawata, kia kau e tonu ngā whakaaro, kia kaha ai i te pakanga nei, i ngā pakanga nei, kia taia o koutou wawata. Kia ora mai tātou. Nō reira huri noto tātou whare. O koutou e manaki ana i a mātou ngā kai tono o koutou. Ngā ringa wera i roto i tēnā whare, i mahi rangatira ana, kia whāngai ai a mātou, i a tātou, a tēnā koutou, kia ora mai tātou katoa. Hungaroia, Ashanti, orango mai. Moto mahunga, o ake ake. Tēnei mātou, o te umaroia mai e. Tēnei kia tātou katoa. E aku rangatira, Apiti ono tātai ono, tātou ngā mahi kia mahi, kia ora mai tātou kato. Kia ora, hunga. Kia ora whānau.
taiparika i o koutou.
E te mihe koe, e koutou, a koa, ko ngora tu tako whananga o te whakatohe, i roto i a koutou, engari ki te tonu ana tana wairua i roto wanginu i a koutou. Nau reira, nā mihi ki a koutou. Nā mihi ki a koe e hami me tō ropu tāhai, mea nei koe, nau tāhai. Nau reira, nā mihi ki a koe. Nā mihi ki ngā roia. Kāna nei koutou te awhina i a mātou, ngā tini hapu. Kei te mihi nui ake kia koutou e te taumata. I tua kei roto i te pākiri mua i a koutou nā te taonga, a te maui. I timata mai te maui i roro o te maunga o panguri. Te maunga e toi nei tō tāua i o ngāpuri, te nuinga o tātou maunga koriro koto. Hakoa tōpua ke o te rākau maunga o koriro koto. Nō reira, kei te mihi ake ki te taonga, i tuka mai e koutou ki a haumaki roto i tēnei whare o tātou. O tā ki te wā, o hoki eia. Tana nohotanga, te mana o ngā puhi ki hoki anga. O ea e tua kei, te haka wā te a iaia. Kei haere koutou ki te kai ani, ka ware ware, taunga tapu anu kei nuku te whare. Nā haka wā te eia, ki tua tai, te haere tonga ki te kai. Tēnei nā kōrero mōna, o ia tēnei kōrero. Ke hoki raro i te whakaru ki papata te rua rei te rapara. I ngā uri atu whare te rangi. He anga i ki te hoi te rangi, tū te rā, tū te pō. O ngā kōrero e rao ngā pu. I te pō, i te rā, ngā kōrero a ngā pu. A heki koi ke raro, e kore koe ahi i te kōrero, i ngā haora. E hare te ure e mea ana o Ngāti Prau. A hare mati roto Ngāti Prau, ka pera mai Ngāti Prau. Hare me koutou te haora te ure e hare. Koe ai, e kore wake ne mihi ake nei kia koutou. I tuko mai, te hau mai mātu me te taonga nei. Ko hoki o hianga, e tana taonga. Nā re nā mihi kia koutou. Nā re huri no tō tātou whare. Tēnā koutou, ākia.
Paraoa o ngā pui, whakaro mō mai. Whakaro mō mai.
E ilo I tēnā, Maku e haria tēnā I ilo I tēnā.
Hei wini ti hei wana kia puta atu I te whea ki te awa. Ka atu tēne ki. E kōrero ana ngā rāngi mauna. Ko te whare tapo a ngā puhe he ngā hanga. Ko te kui e tako tale te papa. Ko te kaumatu e turiho nei te tuanu. Ke kona ano ko ngā paupau me timatahi aki tōku paupau. E tūana ki te puaha o te Terenga plau. Ko mamai a tērā titiro ki tū te moi. Tū te moi titiro ki maunganui. Maunganui titiro ki puhanga tohora. Puhanga tohora titiro ki whakatere mana wakai aia. Whakatere mana wakai aia titiro ki tera maroa. Tera maroa titiro ki whiria. Te maunga tapu o ngā puhi. Te pai ako te nini. Te kawa o rahi. I reira ka whakapiti atu te moano kupe, ki e tai atu ki pamuru ki papata, ki te rākau patapata e tūrana ki te haumau. Pamuru papata titiro ki maunga taniwha. Maunga taniwha titiro ki tokerau. Tokerau titiro ki rākau mangamanga. Rākau mangamanga titiro ki manaia. Ki te maunga e tīmatahi ai, tēnei whakahini nā kore. E kala e totu e mihi ata nā te ape. Nā ngā kōrero, mo te whare nahi o te taitokerau. Te tuanui. Kua tata ngaro atu e nā kōrero e kala e totu. Nā reira nā tō tū ki te kōrero me e nā kōrero. Ko maumaharatia mātou te whare o te taitokerau. Tēnā rā koe. E te trei tūnara. I roto I ngā tau, ki haere me kauta ki tōku maunu. Ka haere me kauta ki kone ka taitai mai ngā hapu. Ki te whakatakoto I wā rātou mamai. I wā rātou awanga. I wā rātou raru ki mua I a koto. Mā koto e whakaro mamai. Mā koto e tātari. A te wā mā koto anō e whakawā. E ana tuana mātou, te iwi Māori o te motu tutanua, ki a koutou, rapuana mātou I te awhina. Ki te kōrero I wā mātou kōrero, ki te karauna. Nā reira, e ngā me no te trei tūnara, whakaro mamai, whakaro mamai, whakaro mamai. Kia kaua koutu e haere mei ki kone, haere noi honai. Engari ke puta atu koutou mauri atu ngā kōrero a te imi. Ngā awanga. Ke taenga ngā taringa o te klauna. Ki te whakalonga mai. Ki te mamai o te imi. Ngā rere mihi atu na te koutou e kala I te kai whakawa. I te mea koe e tēni whata koutou noho mutunga. I roto I a mātou o whamare te Terenga Paraoa. Engari ka hore anō ke au tima tā koutou haere. A muri a tō tēnei ka tae tu koutou ki wainga nui. I o mātou whanaunga o te whamaroa. Engari ko weitangi. Te mauna o rākau mangamanga. Te pauwhaka mutunga mo koutou. A muri a tō tēnei ka tae tu koutou ki tērā o ngā pau. Ki masakā, ki toherau. Engari ko te pauwhakamutu o koutou, ko rākau mahama. Pai kawa hawe mohi ana, he ha te pai, kei te mutunga o te rori. Pai no ka te mea nui mōku e ki tene. I haere mei te imi ki konei, ki te whakaputa I wā rātou kōrero ki a koutou. Nāre e mā koutou e nā kōrero e mauria. Ki te ana o te raiunga, mā rātou whakarongo me. Wei e tēnā ko tā mātou hia. Ko tā mātou kōrero ki a koutou. A whina tia mai a mātou, te iwi Māori o te motu. Nā reira,
E kara e kihi, tēnā rako. Tēnā rako e mihi mai nā, ki te iwi e nohone. E reo, o te Tribunal. Kia hoki atu koutou, I runga I te rangi Maria, I runga I te aroha, I runga I ngā whakaaro o te iwi e nohone. Kia tai pai atu koutou ki mai ngā nui o koutou whāmere, o koutou hapu e tatani ana, kia tai atu koutou ki mai ngā nui ana. Engari I mua tua tā koutou putana atu, e ngā memo o te Tribunal. Ko te hia o ngā hapu nei, kia huatu kia koutou te kahi taunga auha, kia mauri atu e koutou ki roto poneke, kia kiti atu koutou kia matakitaki atu koutou ki tēnā taunga, ka maumahara atu koutou ki ngā kōrero e kōrerungia nei, te iwi I roto I tēnei whare e tūnei. E a kurangatia e huni atu ana ki tēnā reo. Hākua he reo motu hake tō kato reo mau. E ngari ko taku kōrero ki a tātou, kia kaha tātou ki tō tātou reo. Kia uru ki tu hio tātou tika. Members of the Tribunal, it's with much aloha and with much respect that we stand to greet you today and that we also stand to bid you farewell, because this is your last noho amongst us here in Whangarei. And so I am greatly privileged, on behalf of the tribes of Marae, Mahurangi, Makahia and Hokiranga, to bid you farewell on behalf of us. On your returning to Poneke, may I ask Miuni Kingi to make the presentation that has been brought here today. And to make a presentation to you, the Tribunal, to hang in your office, so that every time you look at it, you will remember the kōrero that's been spoken to you in this courthouse today. I let me present to you the mountains of Whangarei Te Terenga Paraoa Manaia and the ocean of the Terenga Paraoa. karanga atu ke hoki me koutou ki te awhina mai i ngā kōrero. Ai ni ka hoki atu koutou ki o koutou kāina, moe ai. Nā reira moe mai i runga i te urunga te whakārahia. O koutou matenga, kei te urunga te takahuti. E moe. Tō tātou kuia e te Terenga Paraoa, i a Tiupiri, i tēnei rā ka whakahokia ki te kōpu o te whainga. E taki atu ana ki aia ki a rātou kua wehe atu te pō. E moe. A piti hono tātai hono ko rātou te unga mate ki a rātou. A piti hono tātai hono ko tātou te kano iora ki a tātou. E a kaukia mei ena ngā rārangi kororo ki a tātou e no hoku i tinei. I raro i te tāhuhu whakaini kororo tō tātou tukuna whare e tui honei. Tēnā koutou. Te ore e tunei a reta. Huri noa, I roto I a tātou ngā mea kua mahu e mei murine. Tēnā koutou, kia o na hui mai tātou.
Kia ora no tātou, te pare I tua ki tēnei, te tautoko aki nā te mihi e tēnei aki. Kai te hoki te tōratuna rea. Mihi atu kia koutou, te tati mihi atu kia koe. Te tati I tēnei taha, mihi atu kia koe. E pai te tohu, e noa ngā tati I rungi e tō tātou nei pare I tēnei rā mutunga, I rungi te Terenga Paraoa. Mai anō mihi atu kia kaurua. E koe hoki te pāpā e āme e mihi ati kia koe me tō roku. I tēnei wā kia kaha koutou I roti tō koutou I kaitanga. I rungi te matua te whenua ana te atua e manaki chaki a koutou I mua koutou nei I kaitanga. Ka leire e mihi atu kia koutou katoa. E tika hoki I tēnei te mihi ati ki ngā hapu tini. E tika hoki te kōrero, ngā tupu I rungi te kōrero, kōrero. Marama mai ngā hapu o ngā pui. Marama mai. Oe nō. E tātou mai, karana nei atu rātou ngā rangatira I tērā taha. Whea mai rātou, ka reri te kai. Whea no tēnā koutou, kia rono tātou.
Taipari, mau ngā karekia, hei whakakapi tēnei, whakapaingia tātā te kai.
Tātou ma, tō tātou e ata e ka kore tō tātou karakia whakāria mai tūtū mai tātou tātou. Nā rere tuku nātu te reo whakamwemiti te reo whakapētei kia koe. Mau ne kaha nei te manaki te tiaki a matu mai te tīmata tango tēnei hui, te rewa mai ki tēnei wā. E te atua kahawa e ino e tu mātu kia manaki tia tonu tia mātu e hoki atu nei kia o mātu kāinga. Kia o mātu whānere e tatari ana kia te e tu mātu ki vai nganu ia rātu. Te kai e tu mātu ki reiro e runga i tu alo hanoa, kia kaua ngā mea ki kino e pāmai ki runga ia mātu. Ka tuku atu tēnei ino kia koe runga i te ingoa tai tamo he wharetu tu mātu kai whakaora. Āmine. Taru atuana ngā tāma ki utanu. Tēnei ka tuku atu koutou ke hoki atu koutou ki o koutou kai. Mā koutou kai manaki koutou e manaki. Ka tuku atu koutou i runga i te ingoa te matu.
Ko maunga tani whā te maunga, ko maunga muka te marae, ngā puhi te whare hokianga te moana, ngā puhi nui tonu te iwi e ngā reo, e ngā mana e ngā kāranga ranga maha nau mai, haere mai. Tau toko.
Ai hoi nā rā te whānu me mihi nui an hoki kia koutu hono mai ki tēnei. Ko tino taiki te wāka mutu mani ka ngā ahutanga katoa e pāna ki tēnei hui nui mō rātou ngā mahutanga o rātou mā ngā whānu me ngā hapu e hikoe ana rātou mai ngā kāinga mō tēnei ko te wahanga mutunga mō rātou ngā kaituku ngā kremi mua e te ropu whakamane te tiriti o waitangi me rātou ngā hapu me ngā whānu. Hoina ka mihano ki kia lātou mai mahurangi manga kāhi mō hianga. Kia lātou te ronga o tēnei wiki me ngā kōreri whakaputapota ki te ao koronga koutou kia lātou ki ngā wawata, ki ngā tangi me te tino kaupapa e pā ana ki te mana motake, te rangatiratanga. Koronga tātou ki te reo me te waitanei ko mātou enei e tuake ana he whakaputanga tino rangatiratanga e taonga nui kia tuku iho mai rā, iho matu kore, iho he mana atua, he mana tūpona, he mana whenua, he mana tangata. Ko te triti o Waitangi, he kiri mana, he ture tangata, he kawanata, he ture wairua, kia tūturu whakapūmau te mana motuhake. Hoi rai te whānau, ka mihi noki kia lātou ngā whānau me ngā kaitiaki o tēnei kāinga o tātou, tēnei rohe o tātou, rātou e manaki tia. Tuku te reo aroha kia lātou katoa mō ngā manakitanga mai te timatanga o tēnei huihunga taino hoki ki tēnei wā. Me te tino mihi hoki kia lātou ki ngā kaiwhakahaere ki te kaiwhakawā Judge Coxhead kia kihi me rātou i runga te ropu whakamane te triti o Waitangi me ngā tini whanonga noki i haere mai nei rātou i runga te karanga o tēnei hui nui mō ngā pui whānui. Me tuku tino mihi nui kia kouta ngā kaiwhakarongo. Kouta ngā whanonga katoa puta no te ao, ka mātaki koe kia mātou i nahi rā taino hoki ki tēnei wā, ka mihi ki ngā āwhina mō tēnei kaupapa. Ara ko Nietzsche me Shane ko rawatahi e kahana ki te mau, te tahonga mihini kia mihi kia rātou, me Raven me rātou noho mai nā hangi i manga moka i te tari o te reo takiwā tautoka ka mihi kia rātou katoa. Hui anō, ka hau tēnei e tuku whakamihi whakawhetai anō hoki kia koutou, men kia piki te kahatu ora kia koutou ngā wā katoa, kia kaha rātou ki te maunga kaupapa o rātou mā ngā mātou tupuna, atu wāka tūtoki hoki ngā wawata, ngā moia, ngā tangi o rātou mā Māori tū, Māori ora.
Whakarongo mai ki te reo e tangi nei, e ringi hia mai ana, mai aku ka mo, ngaro e mātai. Whiti mai te rā, ngaro ana te mamai, ngaro noa te pōuri, kaua e mauriri, anei anō he rā. Maranga mai e te iwi, o ngā hapu ngā puhi, Kia mau, kia u, kia pu, puri ai, ki ngā